Barnes, come on up with your attorney. Thank you.
Good morning, Your Honor.
There we go.
Loading right now, but everything else is up.
All right, this is docket 25-1145 FH. People of the state of Michigan versus Michael Wayne Barnes Jr. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Michael Barnes, standing to my right this morning.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. I need you to keep your voice up, sir. Have you taken any medication, alcohol, marijuana, anything yesterday or today?
No.
Are you supposed to be on medication you're not on?
I'll get back on it.
Is it anything that would interfere in your ability to understand your attorney?
No.
And any sign of fever, COVID, or other illness?
No.
And you've had enough time to speak with Mr. Feigelson?
Yes.
And you've reviewed the pre-sentence investigation report?
Yes, ma'am.
Thank you. Sir, counsel, move the microphone closer to him. You need to keep your voice up, all right, sir? All right, and sir, you pled to weapons carrying concealed punishable by 5 years. You recall that?
Yes, ma'am.
All right. On behalf of the people, any corrections, additions, deletions?
One brief correction to the body, Your Honor. On the cover sheet, in the plea agreement section, it states kilogrew/Cobbs. I want to make it clear it was just a kilogrew agreement, so I believe that Cobbs should be crossed off.
No objection. I think that
That's
makes
accurate.
sense.
I rarely do comps, so I would remember that. All right. And is that then under evaluation plan or anything else? Let me just
I
look.
don't believe so, Your Honor, but let me double check.
I didn't see it, Judge.
All right, I don't see it either.
I don't either. It looks like it just was referred to as a kilogrew evaluation.
Yeah.
Okay. Thank you. And any other corrections, or was that it?
No other changes to the body or the guidelines, Your Honor.
Mr. Feigelson?
No other changes other than the one pointed out by Mr. Buxton, Your Honor, including the guidelines.
Thank you. On behalf of the people?
Yes, Your Honor, I do believe that the recommendation is appropriate from probation, given the defendant's lack of a criminal history. I do think that a weapon safety course would be appropriate, but besides that, Your Honor, I'm in agreement with the recommendation. Thank you.
Thank you. And counsel?
Yes, Your Honor, I do support the recommendation. You want to point out, I believe, prior to taking the plea, Mr. Barnes did complete a weapon firearm safety course, and I believe that verification was given to probation at the time of the pre-sentence interview.
Sir, you completed a class?
Yes, ma'am.
Larry? Oh, yes, I do. I'm looking in the evaluation plan. In the fourth paragraph, it said, or says, defendant completed a firearm safety course and verification was provided.
It does, Your Honor. Thank you.
All right. Sir, what would you like me to know? Well, I understand that. So tell me this, what have you learned from this?
Put your stuff up yourself.
Follow the law, pay attention, follow through. Yes? All right. Sir, I am going to sentence you to 1 day jail credit for 1 day. And you'll pay a crime victims assessment amount of $130 and a $68 state costs. That is $198. How much time do you need to pay for that?
Due date about right.
Okay, so I'm going to give you until October 31st, just in case you forget.
Friday, we'll get it done Friday.
I hope so, because that'll close the case. Okay,
Good enough for me.
all right. So I want you to pay it by Friday, but just in case, life has a way of happening. So by Halloween, you're going to pay it, otherwise late costs come in, and the state's not very kind about that, so that's why I gave you some time to pay. Friday would be perfect, because then we'll close the case. You have 42 days to appeal and to request appellate counsel. The weapon and any contraband ammunition was already seized or forfeited, so I think we're good. 42 days to appeal and to request appellate counsel.
You have a copy of the form, Mr. Barnes?
All right, any questions, sir? Good luck to you, sir, thank you. Next matter.
Yes, Your Honor, it will be Adrian Del Toro.
Michael Barnes.
Where is he?
Page 3, second one on
I
page
hate
3.
this new form, I can't find it. I know, it's weird. So who's coming up next? Next,
Adrian Del Toro, Your Honor.
We have documents to be signed, Your Honor.
so final pretrial, is this going to be a plea?
It's going to be a plea, Your Honor.
You sound.
Yeah.
Judge, it's gonna be no contest plea because,
Done.
intoxication. Your Honor.
Okay. You. All right, this is docket 25-6717 FC, people of the state of Michigan versus Adrian Del Toro. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Adrian Del Toro this morning. Your Honor.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Oh, yeah.
Is it anything that would interfere in your ability to understand the court or your attorney?
No.
Is there medication you're supposed to be on that you're not on? And you need to speak up, sir. This record isn't for me, it's for you, so it needs to be a good one, okay? Is there medication you're supposed to be on? Any sign of fever, COVID, or other illness? Have you had enough time to speak with Mr. Feigelson?
Yes.
All right, thank you. And are you a US citizen?
Yes.
And I understand that there's not going to be a final pretrial, that you've chosen instead of going to trial to plead today, is that correct?
Yes.
And are you a US citizen?
Yes.
All right, do you generally work? When you're not in custody, do you have a job? What kind of work do you do?
I haven't worked in a while. Yeah.
What kind of work do you do? Odd jobs, what?
Yeah, like construction jobs.
Construction, okay. Did you graduate high school?
No.
Have a GED? How far did you make it in school?
10th grade.
Okay. And I have an unknown address on the felony information, and I noticed on the advice of rights form, you didn't put an address other than the jail. Are you homeless?
Yes.
Do you have family you can live with or any other?
Yes.
You do, and why aren't you living with them?
Oh, I had just got there like 2 days to move in and I can.
Okay. On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant will be pleading to count 3, carrying a concealed weapon, which is a 5-year felony. Count 4, resisting or obstructing a police officer, which is a 2-year felony. And felonious assault or assault with a dangerous weapon, which is going to be an added count 6, which is a 4-year felony. Upon successful plea and sentencing, count 1, armed robbery, count 2, carrying with unlawful intent, and count 5, resisting obstructing a police officer will be dismissed. And in addition, the habitual offender 4th will be reduced to a habitual offender 2nd offense notice.
Full, fair, accurate, and complete?
Yes, Your Honor.
Counsel, I'm sorry, sir, full, fair, accurate, and complete the plea agreement that was just stated on the record? Is that your understanding?
Yes.
And there'll be a no contest plea because of intoxication and ultimately also because of civil liability?
Yes.
And counsel, are you waiving reading counts 1, 2, 5, and the habitual 4th?
Yes, Your Honor.
So on the sheet that has a sentence agreement, I am adding, because I don't see it here, it just says he's pleading to the habitual 2nd, but I'm adding the habitual 4th will also be dismissed.
Understood. Thank you, Your Honor.
Okay, just for clarity, may I have the original? All right, as to the reading of the felony information.
Yes, Your Honor. People of the State of Michigan versus Adrian Esparra del Toro. State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 3, weapons carrying concealed, on or about November 19th, 2025, at 221 Mack Avenue, East Lansing, Ingham County, State of Michigan, the defendant did carry a dangerous weapon, to wit, a non-folding stabbing instrument concealed on or about his or her person, contrary to statute. As charged, that is a felony punishable up to a maximum of 5 years or $2,500 with mandatory forfeiture of the weapon or device. Count 4, police officer assaulting, resisting, obstructing. On or about November 19th, 2025, at 221 Mack Avenue, East Lansing, Ingham County, State of Michigan, the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Jason Cotton. A
Jason
police
who?
Cotton.
Thank you.
A police officer of the East Lansing Police Department that the defendant knew or had reason to know was performing his or her duties contrary to statute. As charged, it is a felony punishable up to a maximum of 2 years and or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And added count 6, assault with a dangerous weapon. On or about November 19th, 2025, at 221 Ann Street, East Lansing, Ingham County, State of Michigan, the defendant did make an assault upon Ian Anthony McClellan with a dangerous weapon, to wit, a non-folding stabbing instrument, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to statute. As charged, it is a felony punishable up to a maximum of 4 years and or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Habitual offender second offense notice. Take notice that the defendant was previously convicted of a felony or an attempt to commit a felony, in that on or about November 12th, 2024, he or she was convicted of the offense of attempted police officer assaulting, resisting, or obstructing in violation of MCL 750.81D1 parentheses A in the 66th District Court for Shiawassee County in the state of Michigan. Therefore, the defendant is subject to penalties per statute. That penalty being 1.5 times the amount, the maximum sentence on the primary offense, or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. For count 3, Your Honor, that would make the maximum 7.5 years. For count 4, Your Honor, that would be a maximum of 3 years. And for the added count of felonious assault, that would make the maximum 6 years. The court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition if not taken at the time of arrest and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes.
So you understand count 3, carrying a concealed weapon, normally punishable by 5 years. Because of the habitual second, it is 1.5 times. So therefore, there's an enhancement to up to 7.5 years. Count 4, resisting, obstructing, normally punishable by 2 years, is now punishable by 3 years. And felonious assault is normally punishable by 4 years, but with habitual, again, 1.5 times would be up to 6 years. Do you understand how that works?
Yes.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yeah.
Did you understand what you read and signed?
Yes.
If you had any questions, were you able to ask those of your attorney?
Yeah.
Do you have any questions about your rights of this court?
No.
And you've chosen to plead. Have you chosen this of your own free will, no one forced, threatened, coerced, or promised you anything other than the plea agreement? Is that correct?
Yes.
And you made this decision after talking with your attorney?
Yes.
And you've been satisfied with the representation of your attorney?
Yeah.
And Mr. Feigelson, he indicated earlier that he had taken some medication. Do you believe he's oriented to date, time, and place, and does understand what's occurring?
I do, Your Honor.
Thank you. Sir, as to count 3, carrying a concealed weapon, I understand you're pleading no contest based on civil liability and intoxication. So as to count 3, weapons carrying concealed, how do you plead?
Contest.
And as to count 4, police officer assaulting, resisting, obstructing, how do you plead?
No contest.
And as to count 6, felonious assault, how do you plead?
No contest.
And sir, has anyone told you what I will do at sentencing? I know you look at me like it's a trick question, everyone does, but it's really not. I just need to make sure that no one's promised you something else, so we have to ask things in a number of different ways. That's the right answer. No is the right answer because I don't know much about your case. I am going to learn a little bit today, but I don't make up my mind what I will do until I'm fully informed, and that's at sentencing. Do you understand that?
Yes.
Okay. Let's see, by stipulation of council, I have been provided a couple of pages of the police report. It is from the East Lansing Police Department, case report number 2536403436. The report date was November 19th, 2025, the date of the incidents. And it appears that the reporting officer was Jason Pass, and he has prepared this report. And it states that on November 19th, 2025, he was assigned day shift road patrol. He was in a fully marked squad car wearing a Class B uniform, making it clearly recognizable that he was a police officer on duty with the city of East Lansing. Dispatch sent to him at 16:26 hours on that date a broadcast that a felony was in progress for an armed robbery at Spartan Spirits 221 Ann Street. And that is in the city of East Lansing, County of Ingham, state of Michigan. At 16:25 hours, the reporting person, Caitlin, Kaitlyn Breagh, who was a customer inside the store, was originally reporting a troublesome subject who was harassing workers and making threats. And the accused description was a 50 to 60-year-old Hispanic male, last seen wearing a gray hoodie and gray sweatpants. And she advised that the male appeared to be on something. Law enforcement responded to the scene with caution, checked the area, and was unable to locate the suspect, but made contact with Spartan Spirits to ensure the accuracy of the suspect description and last known direction of travel. An initial contact was made with defendant with the victim, Ian Anthony McClellan, and the victim, Ian, I-A-N, Anthony McClellan, M-C-C-L-E-L-L-A-N, who advised that he was unable to pull up the security footage until the store owner was on scene. He said that the owner was en route. He confirmed the description that was provided to dispatch was accurate and further advised that the suspect was a regular homeless subject who is normally seen wearing a hoodie with the hood up. He said that the suspect also had a part of his nostril missing. This suspect was later identified as Adrian Esparza, E-S-P-A-R-Z-A, Del Toro, D-E-L-T-O-R-O, date of birth 2/4/1983. He confirmed that Del Toro's last known direction of travel was southbound MAC Avenue when he lost sight of him, and said that Del Toro stole some Red Bull, Fireball, and Buzz Balls, BUZZBALLZ''S. He described the knife that Del Toro used as a flat kitchen knife, and then McClellan used his hands to estimate the size of the knife, showing approximately 6 inches between his hands. Further, he said that he could tell Del Toro was getting irritated because of his body language while he was at the counter of the store, and that he appeared to be super drunk and was upset about a transaction that occurred in the store. Further, he said that Del Toro paid for items in the store and that another employee in the store was not giving him the items he paid for. The officer then observed Del Toro inside Puff Puff Tobacco. And he was standing inside the store talking with an employee at the counter. He recognized Del Toro from previous encounter with him and indicates that he had spoken to Del Toro on numerous occasions as he's a regular homeless who stays in East Lansing. Due to Del Toro matching the description provided and being suspected of robbing Spartan Spirits at knife point, the officer unholstered his duty handgun and moved southbound to MAC Avenue, keeping his gun in the, what is that, SUL position?
Standard operating, I guess, or ready position maybe.
I don't know, it's some abbreviation, SUL, I'm not familiar with. SOP would be standard operating procedure, I don't know, well, regardless. He stepped southbound to clear my backup, or his backup, as there was an employee in the store. As he was stepping southbound, Del Toro started walking toward the officer and he yelled, "Come outside with your hands up," and the officer gestured with his hand, further instructing him to come toward him. Del Toro did not listen to the command. The officer again yelled, "Come outside," a second time while he was gesturing for him to come outside toward the officer, and Del Toro did not listen. He started to step toward the corner of the store where Officer Monroe advised she saw a knife on the ground. Del Toro was moving directly toward where Officer Monroe indicated there was a knife. Due to Del Toro moving toward a knife while there was still an employee inside the store, the officer, along with Officer Menser, MEN, SER, decided to make entry. Collins said that he walked around the counter to remove Del Toro from the store and that he was concerned about the safety of his customers. McClellan advised that once he approached Del Toro at the front door, Del Toro pulled out a knife and started threatening him with it, and said that Del Toro said, "Do you want to die for this?" numerous times. McClellan gestured in a slashing motion with his hands while he recounted what Del Toro said to him. McClellan said that he was attempting to de-escalate the situation when Del Toro took a shot, and McClellan believed that Del Toro was amping himself up to come stab him. I think we have the elements. Do you need anything else read from this?
I don't believe so, Your Honor. The only thing is the habitual offender status.
Well, and I don't have that, but counsel would stipulate that defendant was convicted of a felony on or about November 12th, 2024, being convicted of attempt police officer assaulting, resisting, obstructing in violation of the statute in the 66th District Court for Shiawassee, State of Michigan.
I can stipulate to that, Your Honor, but I can also ask Mr. Dottor, do you remember getting convicted of an attempted RNO in Shiawassee County in 2024? Is that a yes? Yes. Okay.
Then the people are satisfied, Your Honor.
Thank you, counsel.
I'm satisfied as well.
Thank you. Our counsel, where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Ms. Court, comply with the protocol.
You
It
have,
has,
Your
Your
Honor.
Thank
Wait a
you.
minute, one at a time. Well,
You have, Your Honor.
You have, Your Honor, sorry.
I could get it, but no. Don't get used to it.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find the no contest plea to be appropriate. It's clear in the police report that he was heavily intoxicated, and there's also an issue of possible civil liability. So no contest plea is sufficient and appropriate in this situation. I also find, based on the police report and the stipulation of counsel and the acknowledgement that there was a prior that the habitual second should go forward, and there are sufficient grounds for the entry of counts 3, 4, 6, and the habitual second. Counts 1, 2, 5, and the habitual fourth are dismissed, along with any outstanding warrants related to this file, if any. And any weapons or contraband seized are hereby forfeited. Do we have a sentencing date?
August 19th at 10:30.
I think I can make that withdraw.
I'm not sure.
Fair enough.
I think that should be fine. If not, we'll let you know. I was thinking it was the week before, but, all right, August 19th, at what time?
10:30.
Okay. Sir, you'll need to cooperate with probation. They're gonna come and see you for a pre-sentence investigation report. We can't go to sentencing without that. At this time, without verification of an address, I am not going to entertain a motion for release on bond, but if you'd like to have a bond report, get verification of an actual address, that's something I might consider in the future, but under these circumstances, no.
Yes, Your Honor. We'll work on that.
All right, I'm sure you will. Thank you. Sir, you getting what you need in the jail? Are you getting what you need in the jail?
Sure.
Yes? Do you have an ID? Do you have
Yeah.
a,
No,
Okay.
I lost it.
okay, and that's why I'm asking.
I don't even know the address. I haven't talked to any of my family, so
Okay,
I'm,
they have a social worker who can help you, and the other thing is, I asked you about the ID, because the jail does have a program where they can help you with that. So inquire about that and avail yourself of that, because without an ID, without an address, so you're gonna be in the Ingham County Jail where I can find you. I'm not gonna allow you to be wandering the streets, and the homeless shelters are full, and so there's a matter of safety, not just for you, but for the community, so. It's something we can work out later, maybe, the circumstances have to be right. I need to look at public safety as well as your safety. Do you understand, sir?
Judge, our social worker will be in touch with Mr. Patorson.
I'm sure they will. So, sir, while you're in the jail, avail yourself of getting an ID, attend CATS, AA, NA, start working on some things. All right?
no,
You're in all that? Very good. You doing okay?
Yeah.
Okay, I'll see you in a few weeks. Thank you. It's all for the record.
We're gonna do Irvin Bertley next.
Ten thirty.
This is docket 256739FH, People of the State of Michigan versus Irvin Bertley. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Robert Easton on behalf of the defendant, Mr. Bertley, who is present standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand down. And sir, you taking any medication yesterday or today?
Yeah, medication today is for colitis. It's called Melazine.
I don't even need to know what it is. I don't want to interfere with your privacy here. I just need to know if it's anything that would interfere in your ability to understand your attorney report.
No,
Counsel, do you believe he's oriented to date, time, and place, and does understand everything?
I do, Your
All
Honor.
right, seems like he's very alert today. And sir, is there medication you're supposed to be on that you're not on?
No,
Any sign of fever, COVID, or other illness?
no,
You had no time to talk with your attorney?
yes,
And have you reviewed the pre-sentence investigation report with him as well?
yes, Your Honor.
All right, thank you. Any corrections, additions, deletions on behalf of the people?
No, Your Honor.
On behalf of defendant?
Yes, Judge, I would point out just a couple of things. On page 1 of the pre-sentence investigation report, it indicates education level at 9th grade. Mr. Burtley has completed a GED.
Good, and I'll change that to GED, that would be on the cover page, and then in the inside, is it correct or not?
And then it is addressed on the inside. We can provide verification if the court requires that. It just says on page 1 that it's not verified, so we can provide that as well.
All right,
The only other thing I would point out, Judge, is on page 2 under the description of offense narrative. And it does reference the incident report, but then there is a summary on page 3 that indicates a total amount that was seized from the residence. And the court may be familiar with the forfeiture action that was before the court and for another party. The only amount that was present in the house was the $1,000 in his pocket, which is on bullet point number 1. And then the approximately $12,000 that was in his bedroom. The remainder was recovered from a vehicle off of the premises that did not belong to him and was not registered to him, was not on the premises or the curtilage, and belongs to a different party.
so this indicates on page 2, the $1,022, that is what was in his pocket.
That was in his pocket,
And-
it was in a pants pocket of his, and then the $12,000 that was located in the bedroom.
In the pillowcase, okay, so then we also have $205 in a gray sweater, that was not his?
That was his as well.
Okay, and then we also have a black safe of $50,000?
That was what was in the vehicle that was off of the property.
Was that vehicle his?
No,
So do you want me to put in a vehicle not his, was it related to this case? How,
it is our position that it's not related to this case.
on behalf of the people?
You can note that it was located in a vehicle. I have no objection to that.
So I'm gonna put located in a vehicle that was not defendant's?
That's correct.
That's true.
Okay, so I noted that. What about one heat sealed bag containing $50,000? Is that the 50 that was in the black safe?
I believe so, Judge.
Yes,
That same note can go to the 50,
okay.
the 50 and the 51. And the 10. And then under that, it says one black safe vehicle location, so it is noted somewhat, but not very clear.
So that also goes, you said, to the $10,000 in the black safe? Is that a different safe or the same safe?
Should all be the same.
Should all be the same, Judge.
That's not just not very clear how they wrote it, so I'm just adding these notes. Would that also be true of the money counter, the electronic scale, the baggies located in the rafters, the digital scale, who does that all belong to?
Those things were all present in the residence, Judge.
Okay, so these were found in the residence. In defendant's residence?
Yes, Judge.
So then it goes on to say a total of $127,227 was seized. but it appears that only a portion of that was defendants. Would you like me to include that? Do you know how much was attributed to defendant?
That would be the $1,022 in the right pocket of the defendant, the $12,000 in currency in the.
And the 205.
And the 205.
So I'm putting of which 1,022, 12,000, and 205 were defendants.
That's correct.
I think that's needed for clarity given the above. All right, any other corrections?
Not for the defense judge.
And what about the guidelines?
I had no challenges or corrections, Your Honor.
Thank you.
The defense as well, Judge.
All right, and on behalf of the people, what would you like me to know?
I have no comment. Thank you, Your Honor.
Thank you. Counsel?
Thank you, Judge. I've had an opportunity to spend some time with Mr. Bartley over the last couple of months. He's fully accepted responsibility here, recognizes that this is not who he wants to be or where he wants to be in life. As is indicated in the PSI, he's got some young people that he is responsible for.
Well, he had those young people when he did all this too, so that does not faze me one bit, counsel. I appreciate your mentioning it. But that all should be considered before criminal activity.
I agree, Judge, and I think, and my point is that he now understands that in a different way. He's had obviously some trouble in the past, and to find himself in a situation like this in front of the court now, and to have to share with his family that he is, again, risked his opportunity to be there, to be supportive of them, has been, I think a maturing moment for him in the last few months. I think he is motivated to ensure that he is not engaged in any conduct that would risk his future or with his children in the future. He's also been working pretty steadily for about the last 4 years. Has maintained active employment.
Is this with Sir Pizza or somewhere else?
This was Sir Pizza.
You able to support a family on Sir Pizza?
Excuse me, Your Honor?
Are you able to support a family on Sir Pizza?
Not really, I don't really do much. I'm only on child support for 2 of my kids. They take it right out on my check, so.
Anything else, counsel?
At this time, Judge, I would just ask that the court would follow the Kilgore agreement.
Sir, what would you like me to know? You, this is about you. What would you like me to know? What do you think I ought to do? What changes have you made? What have you learned? I mean, there's no easy money, sir. There's no putting drugs in our community. You've got, let me see, 2 children. Are they twins? 16?
No, they're not twins.
Okay, two different baby mama?
Yeah.
Yeah, okay. And then you got 2 16-year-olds, you got a 15-year-old and a 13-year-old. They are of the tender ages where someone like you is gonna sell them drugs. Is that what you want?
Yeah.
Well, then why are you doing it to the rest of us?
No excuse, Your Honor.
There is no excuse. Every single day in this community, somebody dies, a child dies of gunshots and illegal drugs. And all our children are related, so it hurts my heart when somebody else's child dies, because it could be mine, it could be yours. And what I read here, you didn't give a crap about that, you cared about the money. And you're not making enough at Sir Pizza, so what's gonna change there?
But I've been looking for a second job as well.
Oh, sir, you've been looking, how hard you've been looking, because I gotta say, half the stores in this town have help wanted signs, they can't have enough business hours open because they don't have enough workers.
I've been putting out applications everywhere, like factories, they haven't been getting back with me. Just try GM, I just got denied I had a job, they told me I had it, but when they read my background, I had a felony background.
You have what, 10 times you've been in front of a judge, you got quite a history here. But there are employers who take felons. How about school? How'd you do in school?
It wasn't really my thing. The subjects I liked was math and science. That was,
Well, those are the subjects I hate. Those can get you really far in life. Most lawyers don't like math and science. That's why we're lawyers. Okay? What do you want to do? You want to work at the pizza shop the rest of your life? You want to own it? You want to own it or work there?
I would rather own a piece of shop than work there.
Okay, how can you get there? What do you want to do?
Gotta put it in the ground and start working harder. Working myself harder.
Okay, and that's a nice tune in a song, but how are you gonna get there, sir?
Gotta find a better job and start.
Okay, so. I'm gonna send you to your jail, but I'm holding the banks. Counsel, don't come to me with another song about his family. I'm not gonna listen. Your little chat about the hard work he's gotta do. Sir, you got 4 kids and you're not supporting them. You're supporting 2 that take child support, what about the other 2?
My son lives with my 15-year-old, he lives with me.
Okay, are you getting child support from the mom?
No,
Why not?
we have an agreement. She get them on the weekend and I have them go in school, she get them on the weekend.
So what? You have it most of the time, you're entitled to child support. I mean, I haven't run the numbers, it's a family court job. Is she working?
Yeah,
So you don't think that some of her paycheck ought to go to pay for his necessities?
I mean, yeah, it can, but I'm not gonna say that she doesn't help, because she helps.
Okay, and what about the other child?
My other child, my oldest son, and her have the same mom. They live together. I can't really say they don't take the child support out because she's on the case file, but it don't never say they take that out for us. I don't know how that works.
Well, when have you had it, you're entitled to a child support review every 2 years, why don't you figure that out, sir? It takes 2 to play and 2 to pay. And child support is the right of a child and an obligation of both parents. Now, I'm not that smart, I didn't write that. Okay, that's written in the law, that's written in the case law. Every attorney should be able to recite that. That's just the way it goes under the Constitution and the rights of parents and children. So the law does not reward anybody who sits on their rights. So figure it out, sir. Front of the court downstairs. There's a piece of paper on the desk. You can just put your name and file numbers or what have you. And if you don't know, they'll help you get it. And you just ask for a review of child support. It doesn't cost you anything. They'll figure it out. So, have you ever thought about college?
No,
Why not?
just never proceeded.
Why?
Back then, I would just.
I'm talking about now, sir.
Right now, it just never crossed my mind to go back to school. It just hadn't. Not saying that I can't or won't. It just had.
Okay. Well, LCC has a program that's free. How much have you gotten in your life that's free? Not much, huh? Me either. But LCC has a program. I don't know if you qualify, but it is called Reconnect. It is meant for people like you who've been out of school for a while. I'm going to ask you to investigate that and look at what you want to do in the future. You want to own a pizza shop? Take some business classes. You want to do something else? They got lots of opportunities over there. There's 2 things people can't take away from you. Your name and your education. And your education is an insurance policy to your future. Selling drugs, criminal behavior is your insurance policy to abet at the Michigan Department of Corrections and being an absent father. Choose. You are going to be on probation for 24 months. You shall not use, possess, purchase, be in the presence of any alcohol, illegal drugs, drug paraphernalia. You end up at a friend's house and they have all that, or any of that, you just do an about face and you leave, because they may not get in trouble, but you will get in trouble. You need to change your friends and your lifestyle, sir. Otherwise, your lifestyle becomes real easy. It's jumpsuit, some Crocs, 3 hots and a cot. You get to shower and eat and do all those things that people do under the watch of the Department of Corrections or the Ingham County Jail. If that's the lifestyle you want, you got it. Be the example to your children that you can make a mistake, but you can learn from it. These are teachable moments and you can achieve the greatness that you were born to. Every human being, including you, sir, is born to greatness. It's a question of whether you achieve that greatness or throw it away. But right now, I see you throwing it away. So you go the other direction and achieve the greatness, or you will achieve a bed in the Department of Corrections. Be clear?
Yes, Your Honor.
So were you using or just selling? Looks like you had alcohol and marijuana, but you didn't use. Is that right or not?
Correct, Your Honor.
Okay. How about marijuana? Are you still using marijuana?
Yeah, I was, Your Honor. I have a medical marijuana card.
Okay, so you will only use the marijuana as prescribed. When we test you for drugs or alcohol, which will be random, doesn't have to be regular, doesn't look like you have an alcohol or drug problem, we will test for the levels in accordance with that prescription. So you're not allowed to be high every single day. You're allowed to use it as prescribed for whatever medically ails you. Got it?
Yes, Your Honor.
Any prescriptions you receive, you'll present to probation within 24 hours, and you will sign all releases so we can verify that you're doing what you need to do. Before September, actually before August, you will investigate the Reconnect program and see if that's something you want to do. If not, you will also investigate trade school. There's a lot of opportunities for you. You're not making it with Sir Pizza, nothing wrong with Sir Pizza, they got good pizza. But it's not a career for you with 4 children, not making ends meet and looking at criminality to support and subsidize your lifestyle. Not happening, it's not working well for you. You can support nobody if you're incarcerated. So I'm giving you this opportunity. You can use it wisely or throw it away, your choice. You will not give any employer any cause to terminate you. You will not have any abusive, assaultive behavior, verbally or physically. You will not be in the presence of any known gang members. Shall not wear any gang colors, insignia, or gang tattoos. You will not be in the presence of anyone who's on probation, parole, or in the Michigan Department of Corrections unless you have our permission and everybody's in good standing. You will allow probation into your residence or supervision if there's reasonable belief that you're violating, and they'll be allowed to check without a warrant your residence, cell phone, computer, vehicle, anything you have access to. Do you understand?
Yes, Your Honor.
You will participate in cognitive behavioral therapy. You will not have any guns, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has those. You'll not use any object as a weapon. You end up at a friend's house who has any contraband, you do an about face and you leave. They may not get in trouble, but you will. We're clear on that?
Yes, Your Honor.
You have 365 days jail credit for 2 days. Balance is held. They'll report to probation every time they want to see you, no less than monthly. And if you need to miss an appointment, then that's on you. You chase probation, they don't chase you. You will keep them informed of your employment, your school, your address and telephone number. Anything changes, you have 24 hours to tell them. If you have any police contact, personal protection or placed on you, any change whatsoever, you have 24 hours to tell them. And serve something that was on a Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. That's how that works. Do you understand that?
Yes, Your Honor.
You will pay crime victims assessment amount of $130 and a state cost in the amount of $68. I am waiving probation oversight fees and finding you're indigent for that and any and all other costs. And counsel, were you retained or appointed?
I was retained last time, just.
All right, so everything else is waived in terms of fines and probation oversight. Is there anything I have missed?
Not on behalf of the people, Your Honor, thank you.
Not for the defense, yes, thank you very much.
Sir, this probation is for your rehabilitation. It's up to you to do the hard work. Additionally, it's up to you to be honest. Now, if you decide not to do the Reconnect program or go to trade school, you might need to get a second job. Things are going up. Gas is what, $5 a gallon? Eggs are expensive, everything's expensive. So get a second job. But again, you can lose a job, you can't lose your education. The Reconnect program, hopefully you qualify for that, but there's also a lot of trade schools. Work with probation to figure out what your next step is. And climb the mountain of success. Because right now you're at the bottom of the mountain and you don't know which next step to take. There are counselors who can advise you. Probation can work with you. Ask for help. That's a sign of rehabilitation. That's a sign of strength. I don't believe that you want to be in this place. I think you think your options are limited, and they are not. The only one limiting you is you. Let's get past that. Move past your fear. Failure is just another teachable moment. It's okay to fail. It's not okay to not try. You hear me?
Yes, Your Honor.
You have 42 days to appeal and to request appellate counsel. Please give Ms. appellate rights. They're right there next to you, counsel. Acknowledge receiving your appellate rights. If you don't like this, you just appeal. That tells you how to do it. You have 42 days, okay, sir?
Yes, Your Honor.
Meanwhile, go downstairs, make an appointment with probation. Ground level, keep all appointments. Counsel, if you could direct him, that would be great. Thank you.
Thank you,
Good
Judge.
luck to you, sir.
Thank you, Your Honor. Have we approached for one, Your Honor?
Sure. Yes. Nancy, Leach is gonna be an alley. That's all.
Who's gonna be around?
And Rodriguez is off as well. Cameron Rodriguez.
And why is he up?
We're working on a mental health court agreement.
Okay, so,
I've already gotten a new date from Nicole.
okay,
When is that date?
That is August 19th at 9 o'clock.
You said Damian Gonzalez?
No, Cameron.
Cameron, the
Cameron
third,
Rodriguez.
on page 1.
He's on page 2 also.
Oh, he's also on page 2?
You said August 19th?
August 19th at 9
Or
Cameron.
for Cameron Rodriguez.
Is that just like a status?
Yes.
This is, I'm just gonna, just make a note, he's going to mental health court.
Yes.
Okay,
Nolly.
okay. So who do we got next?
Next, we're gonna do William Krosky.
he's also on page 2, 182.
Why did it end up on 2 different
I
pages?
don't know, he's the first one on page.
I have no idea either, Your Honor, because they're the same case, so.
One says here and one says.
Yes, correct.
So there's only one file, but he's listed twice, and that's
Because
just.
one's a bond violation and one's the final
Yeah,
pre-trial.
It's just a stupid program, that makes it look worse.
I agree, Your Honor.
Okay. All right. This is docket 256822FH, People of the State of Michigan versus William Krosky. Counsel, your appearances for the record, and counsel, if you need time to please approach.
Thank you, Your Honor.
Good morning, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good morning, Your Honor. Jacob Starks the fourth, Assistant Public Defender here on behalf of Mr. Krosky, and will approach the podium, but Mr. Krosky is approaching it. Thank you.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the country perjury?
Yes, I do. Your Honor.
Thank you. Put your hand down. Were you here before and I arraigned you?
Yes, ma'am.
Okay, that's what I kind of I just want to make sure we're on the same page. I think that you didn't have counsel at the time, but we arranged you. Is that what happened, or?
No, we had counsel, Your Honor. Mr. Krosky entered a not guilty plea, Your Honor, granted him an interim bond. We set this for a contested hearing because there's allegations of contact between Mr. Krosky and the complaining witness. And then we were also scheduled for a final pre-trial this morning as well, Your Honor.
Oh, okay, thanks for the update. I made some notes, but I wasn't sure. So are we still holding this in abeyance? Or-
Well, I'll defer to the prosecutor, Your Honor. I believe he has his witnesses here. Mr. Krosky wants to have his jury trial, Your Honor. And so at this point, for the purposes of the final pre-trial, and Your Honor did grant him an interim bond, we would just request to leave this on for the trial. Mr. Buxton has a detective here. To my understanding, he subpoenaed the complaining witness and some of the other officers, they did not appear. So, you know, certainly it would be Mr. Krosky's position that he's posted his interim bond, Your Honor. To the best of my knowledge, there's been no new allegations at this time. Respectfully, on the defense side of things, we would have no objections if Your Honor thought it was a better use of Your Honor's time at this particular moment to hold off on the allegations here until we got this to a trial or disposition of the charges, Your Honor. But I'll defer to the court. Thank you.
On behalf of the people, what would you like me to know? What would you like me to do here in regard to this? If he's going to trial, I don't know if we're stepping on any of his rights by dealing with this.
We would not be, Your Honor. This is a PA 53 violation that did not result in any new charges. So I don't believe we would be stepping on any toes. Ultimately, as you'll hear from Detective Wilson, this was ultimately, it appeared to be a struggle on the street between the two of them. It seemed to be mutual. As I said, I'm not entirely sure if it was mutual or not, but when officers arrived, it was mutual. So I would have Detective Wilson testify in regards to what was in that police report.
Well, let me ask you this, was this, if it happens on the street, do you know or will it come out in testimony if this was an accidental happening on the street, like?
No, Your Honor, the
Or
officers
they were
found them
together.
entangled with one
Just a minute.
another.
I'm sorry.
Okay, I apologize.
Or were they there together and then this ensued?
It appears, Your Honor, that they were together and then this ensued.
Okay. Would you like to have the final pretrial first? Is there an offer?
We can, Your Honor, yes, there has been an offer given, that offer being count 2, domestic violence, and an added count 4 of felonious assault. We would dismiss the remaining charges, which are an assault with intent to do great bodily harm or by strangulation, aggravated domestic violence, count 2. We would dismiss count 3, the aggravated, or the assault with intent to do great bodily harm less than murder or by strangulation.
Wait, so
So,
count 2, let's start again, with aggravated DV.
Plead to count 2. Dismiss count 3,
Okay,
and then plead to an added count 4 felonious assault. And we would dismiss the habitual offender in count 3. And then there would be a Killigrew County cap. In running the guidelines, Your Honor, I have, if Mr. Krosky go to trial, I've got 0 to 21. Under that plea, I've got 0 to 17, but obviously there would be a county cap. That was the previous offer that was given. So it is my understanding that that does not wish to be accepted at this time, and they wish to move to trial at this point. That trial is currently on August 14th. However, I know that Your Honor is unavailable on that date, so it would need a new date.
okay, it'll be probably a backup to maybe the next week or two, so we won't move it very far. And as it gets closer, I may be available, I just don't know what is, I don't know what is on my schedule is actually gonna go, so trying to stay away from that date. So the felonious assault is a 4-year, correct?
Correct, Your Honor.
Okay, so he'd be pleading, the offer would be that he pleads to a 1 year and a 4-year, and the 10-year is dismissed, which actually is a 15-year because of the habitual offender, which also would be dismissed.
Correct, Your Honor.
All right, full, fair, accurate, and complete, counsel.
Yes, Your Honor, thank you.
Full, fair, accurate, and complete, sir.
Sure.
And counsel, he wishes to avail himself of his rights to go to trial.
That's correct. That's Mr. Krosky, you understand what this plea offer is?
That's not the plea offers for
The plea plead guilty to count 2, domestic violence,
A 1 year.
aggravated, which is a misdemeanor punishable by up to 1 year in jail. That's the tail, the maximum. Plead guilty to an added count 4, which would be a count of felonious assault. Factual basis for that would have been the allegations involving the hammer.
Tell us saying to plead guilty to the count, I'm not pleading.
Do you need some more time to talk?
Yes, Your Honor. Thank you.
Okay, let me know when you're ready. Thank you. And
One moment, Your Honor. Yes, Your Honor. Can we approach?
so,
Yes.
Hey, do you want me to do this? All right.
We just moved, final pre-trial. September 9th. 10:30. We moved to September 9th, 10:30. Like 11:30-ish.
I know that.
Yeah, I like.
It's like those things, so.
I'm happy to do that.
We have a pre-trial case that we're actually can do a plea on right now. There's no other cases ready.
That's fine.
Okay.
Right, what is that?
That
Which case
is,
it?
yes, it is Matthew Raymune.
Yes, it is set for 1 o'clock, actually. for today.
Great, we like moving those, because I have
Mhm.
so.
He is in lockup there, he's in.
He said his lawyer said that.
All right, let me go get.
Review.
Raymune, yes.
Review.
REAUME.
I got it.
Oh, do
So,
you have the?
All right, so Judge,
Old police sheet.
I'm gonna address this real quick.
Yes.
I already-
No for time agreement.
Set for 9:30.
I already reviewed all that with him, so you'll just need to sign it and get it up.
Do you have the?
However.
I have my
rights.
It's now,
I guess I believe I
it's now 11:18, he's still not here. Sufjan apparently, his attorney apparently told him 11:30, he said he got pushed back to 11:30, and I don't know where Sufjan went.
11:30-ish.
well, if somebody's not here by 12, we're gonna probably call him and see what his real thing is.
He's here, Sufjan is here.
No, the defendant's here, the defendant's here?
He said he's here.
Okay.
Where is the lawyer can do it on Zoom if he wants.
The lawyer said he would be here at 10:30, and
Who's the lawyer?
Mark Hart. It's been
I
a,
have another here.
it's been a problem with being late.
Um,
All right, and I will go get this file in the cold.
Okay, and I'm gonna get, so he's in lockup for you?
Yes. Yeah, no contest plea, Your Honor. Intoxication, he was very drunk. You want, I can approach.
May we have Matthew Raymond? Is he up there?
I think he is already.
Is he
He's
up
doing
there?
it, deputy, so. No problem, thank you.
And he'll just need a moment to sign. We've reviewed the paperwork with him. He just needs to sign it when he gets out here.
If you want, we can handle chat, but it's gonna be bench warrant.
Okay, there's, our list is there too.
The one we were just doing, last week, there's that. Well, let's do the benchmark, who's the benchmark?
Deonta Chapman.
Which one?
Deonta Chapman is 11 o'clock.
Oh, it's 11?
Yep.
Who's the attorney?
That would be Mr. Starks.
Oh, you're the attorney? Okay. All right.
Allegedly.
He just wanted close view of it.
Right.
Oh, I do see that, okay. This is docket. First of all, I don't. Sneak format, I can't even see the docket. I guess it's 24693 FC, People of the State of Michigan versus Deontay Chapman. Counsel, your appearances for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Sars IV, Assistant Public Defender here on behalf of Mr. Chapman. Mr. Chapman is not present this morning.
And this was set for 11, it's now 11:21. Did he appear for his pre-sentence investigation report?
No.
Well, bench warrant bond forfeiture.
Understood, Your Honor. Thank you.
And for the record, the people will be asking at an eventual sentencing that the Kilgore is nullified because of his conduct.
We'll make a record at that time. I mean, I don't know, maybe he's in lockup or hospitalized. We'll make a record and figure it all out.
Understood, Your Honor. Thank you.
Thank you.
Better than file.
Confused here.
I have not seen the defendant anymore on Sufjan.
Well, it'll be here 11:30-ish, you know,
He's here.
Okay.
it's on his time.
Apparently.
Have you called back the attorney and to see where he is?
No, I was trying to get that file on radio.
There. So yeah,
Okay,
so we
well,
can get Mr.
they're bringing him
Raymond.
up. Let's deal with this issue, the final pretrial.
But we're going back on,
Krosky.
I know, it's a little confusing.
You certify.
This is Crosby, correct?
That's correct, Russ.
All right, we are back on the record on People versus William Krosky, 25-6822 FH. Counsel, what have you decided in regard to with your client, whether this will be a plea or whether the plea agreement will be held today or we go to jury trial?
Thank you, Your Honor, and thank you for the additional time to meet and review the plea offer with Mr. Krosky. At this time, Mr. Krosky requests to proceed on to jury trial.
Okay, that's correct, sir?
Yes, Your Honor.
Did anyone force, threaten, or coerce you to make that decision?
No, Your Honor.
Anyone promise you anything that could made you make that decision?
No, Your Honor.
You've had an opportunity to discuss all of these matters with your attorney on multiple occasions in addition to today, is that true?
Yes, I have.
And you've been satisfied with the representation of counsel?
Yes, I have.
And you understand that if you are found guilty by the jury, then the guidelines are from 0 to 21.
Yes, I do, Your Honor.
Okay, and that's on the minimum that the court could do. And I have no idea what I would do. I don't know anything about this case, but just so you are fully aware.
I'm fully aware and I understand.
Okay, thank you. And then we will set this for a jury trial. Actually, it's been set for jury trial. It's August 14th. Why don't we just move it a week? And then we'll move it if we need to again. It'll be a backup. So this will now be August 21st. And then we'll keep you informed as to, because you'll be a backup, and even though I schedule 10 or 12, they have a way of all going away, so you may very well go on that day. All right, and then we'll keep you informed. Now, in regard to the Public Act 53 violation.
That's correct, Your Honor. That would be the
We'll
the
go
next
on
part.
your hearing. All right.
Thank you.
Counsel, have a seat. Counsel, your first witness.
Yes, Your Honor. People call Detective Sarah Wilson to stand.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
yes, Your Honor.
Thank you. Put your hand down, have a seat. Feel free to adjust the microphone so you can speak comfortably into it. When you are ready, please state and spell your name for the record.
Sarah Wilson, SarahWillson.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Detective Wilson, how are you employed?
I'm a detective with the Lansing Police Department,
How long have you been a detective at the Lansing Police Department?
about 7 years.
Have you had a chance to review incident report number 26-042391-1?
Yes, I have.
Your Honor, I'm just gonna state just a generic objection here to this detective testifying that because this detective was not personally involved in the allegations here and the investigation here. She did not go to the scene. She's just basically going to be testifying of what she can regurgitate from a police report. The police report was submitted to the narratives by a couple of officers. So, Your Honor, I will just state a generic objection to lack of foundation, lack of personal knowledge, and anything that she'd be testifying to here would be all based on hearsay. Thank you.
So under what court rule does she get to testify?
Your Honor, under the, there's actually the rules of evidence as well as the Michigan court rules. Under the Michigan rules of evidence 11.01, applicability of the rules, it specifically states that the rules of evidence, except for privilege, do not apply to the following. And one of those being, Your Honor, is it? Miscellaneous hearings, miscellaneous criminal proceedings, including proceedings for extradition or rendition, sentencing, granting or revoking probation, issuing criminal summons, arrest warrants, and search warrants, and proceedings for release on bail or otherwise. So it would be, the rules of evidence do not apply for proceedings for release on bail, which is what this would be, Your Honor. Additionally, under Michigan Court Rule 6.106G, in regards to custody hearings, it specifically states, Your Honor, under subsection 2, subsection B, that the rules of evidence, except for those pertaining to privilege, are not applicable. Unless the court makes a finding that makes the findings required. The rules of evidence are not applicable unless the court makes the findings required to enter an order under subsection B1. The defendant must be ordered released under subsection C or D. So the rules of evidence do not apply for these kinds of cases, Your Honor, which is why we would be proceeding with the Detective Wilson talking about the police report.
Thank you. Response?
Thank you, Your Honor. This is a contempt of court trial. This is how this was supposed to be noticed up and scheduled. Because we are in a trial setting, because the burden of proof here is proof beyond a reasonable doubt, Your Honor, and further due to concerns about due process, that will raise a confrontation clause right concern here, Your Honor. Because at this point, this is not the officers who conducted the investigation, who went to the scene, who visited the scene, who talked to the witnesses, Your Honor. This is a detective who is later on reviewing police reports. And this interferes with my ability to adequately confront and cross-examine people who more directly were involved in the investigation itself, Your Honor. Yeah, this detective can only testify to what's in these reports. She's not going to have any personal knowledge about what happened on this particular day on May 24th, 2026. And because this is a contempt of court trial, Your Honor, which is what we're scheduled for this morning, respectfully, to preserve the issue, I would note my concerns about Mr. Crosky's due process rights. Thank you.
Response in regard to contempt of court carries with it 93 days and or $7,500. So he would be subject to 93 days possibly, which does not count for the underlying charges. So do you agree with what counsel just argued?
I do not, Your Honor, because this is not a trial, this is a hearing. The confrontation clause is in regards to trial, not a hearing as in regards to this case, Your Honor. So I don't believe we're running afoul of the confrontation clause. And I just want to make it clear, this is not a beyond a reasonable doubt. This is probable cause in regards to the violations. So I don't believe there is any issues with the confrontation clause. I believe we're able to proceed as we are right now.
Counsel, contempt of court, isn't that by preponderance of the evidence, not beyond a reasonable doubt?
Your Honor, it is an offense punishable by up to 93 days in jail. It is considered equivalent to essentially like a misdemeanor. So, especially when we're at district court, Your Honor, And to the best of my knowledge, in my experience, in the context of a PA 53 trial, which is a judge trial, the burden of proof, because of the risk of up to 93 days, because it's considered its own separate, it's equivalent of a misdemeanor, Your Honor. In terms of Mr. Crosby's criminal history and everything else, it shows up in background checks for convictions of contempt of court. Best of my knowledge, the burden of proof is proof beyond a reasonable doubt in the context of a contempt of court trial.
I tend to agree with you because there is a separate charge, although stemming from this. Probation violations, bond condition violations are generally preponderance of the evidence not beyond a reasonable doubt. This does carry a separate 93 days, which is not applicable to the underlying charge. So I would agree that we can't proceed. So thank you for your time. I think if we want to proceed, we need to have the actual witnesses and drafters of the police report, so we can schedule this for a different day, or we can schedule it for time before or after the trial.
Yes, if we could schedule this for another time, Your Honor.
All right, so my schedule is so congested, I need you to all get that time from Nicole.
Understood, Your Honor.
Thank you for your time.
What was the new trial date?
It'll be August 21st.
Okay, thank you.
As a backup. All right.
Thank you, Your Honor.
Bond and bond conditions will continue to serve. Don't let there be another allegation of this. That will speak to me loud and clear, and bond will simply be revoked until we get this resolved. I don't care if she appears naked at your door. You call 911 and you don't answer the door. You don't say anything like, get out of here. You do nothing. You stay away from her under all circumstances, or I simply have the authority to revoke bond. No other conditions. I won't listen to any arguments. I do have a note in my file that this is your last bond. So don't tempt me. Stay away from her. Understood?
You told me last time, crystal clear.
All right. Thank you.
Thank you.
matter.
Yes, Your Honor, we're gonna do Matthew Rainview.
We're having the students will check this with criminal contempt.
Yeah.
Criminal and civil, pull both.
It is bad.
And then pull the relevant cases. So it was like-
Supposed to be here at 10:30, and nobody contacted him about moving to 11:30, but as of the time I was speaking to her, he was supposed to be pulling into the parking lot.
What do you mean, nobody said he was moving at 12:30? I thought he said he's moving at 12:30.
Yeah, Mr. Hart said he was moving. Mr. Hart, nobody here authorized that move.
Yeah,
Nobody
well.
told him it was okay to do that, because Jessica Farr's been sitting here since
Oh, I know.
9:30.
So, well, okay, so is he pulling in or not?
That's what I was told.
Okay. This is document 262454FH, People of the State of Michigan versus Matthew Heath for you. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Riem. Okay, Riem. I always get that name incorrect. He's here and stands to my right.
So it's Riem, not Ryu.
Riem.
Riem. Okay, thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on the penalty of perjury?
Yes, yes, Your Honor.
All right, thank you. And sir, have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No,
Any sign of fever, COVID, or other illness?
no, Your Honor.
And you had no time to talk with your attorney?
Yes, Your Honor.
And I understand there's going to be a plea today, is that correct?
Yes, Your Honor.
Are you pleading of your own free will, no one forced, threatened, coerced you, or promised you anything other than the plea agreement that I'll hear?
Yes,
Is that
sir.
correct?
Yes, sir.
And you made the decision to plead after talking with your attorney,
Yes, sir.
and you're satisfied with her representation,
Yes,
and you're a US citizen?
yes, sir.
Did you graduate high school?
Yes,
And what is your line of employment?
right now I'm employed.
I understand that because you're incarcerated, but what is there something you regularly do? Are you a carpenter? Do you work at a pizza place? What do you do?
Yeah, I was doing carpentry and working fast food.
Okay. And what you're pleading to, were you on probation, parole, or bond conditions on another file?
No,
Your Honor, if I could just have a moment here to have him put the signatures on the paperwork.
All right, let me just ask him, sir, do you still live in Hassan on, is it Log Court?
60-50 Baylor Court.
Yeah,
Say the.
Baylog Court,
Yeah.
6050 Baylog Court, BALOG.
Yes.
Thank you. All right, take the moment to sign.
You got it, all right. Sweet. Sure, and then print. Is that phone number still good?
Oh, my phone number, I got it right here.
Okay,
I don't remember the number.
okay. This down or is that in where is it located? You have to know which. If it was a
Yeah, 48840.
40.
Go get 70.
Hopefully that pen is not the right one. And if I may approach. Oh, we still have this in the guilty, is that okay? The court, I don't know if the court wants to change it or. Okay, I apologize, Your Honor. Should have called that sooner. That's all right. Yeah, no worries. All right. And then that paperwork, and then because it's going to be a no contest, we have the stipulated two sections of the report highlighted. Oh.
All right, on behalf of the people, what is the plea agreement?
Yes, Your Honor, the defendant be pleading no contest to count one, police officer resisting obstructing, which is a 2-year felony. Upon successful plea and sentencing, the habitual fourth offender notice will be dismissed. Additionally, Your Honor, there is a Killebrew agreement to no upfront jail, and the defendant agrees to a term of probation.
Full, fair, accurate, and complete?
It is, Your Honor.
Full, fair, accurate, and complete?
Yes, sir.
Counsel, you're waiving reading the habitual fourth? Counsel?
Yes, Your Honor, I'm sorry, I'm not reading something, I apologize, yes.
All right, as to the reading of count one.
Yes, Your Honor. People of the state of Michigan versus Matthew Keith Raymond. State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the location described below, the defendant in count one, police officer assaulting, resisting, or obstructing on or about April 17, 2026 at 6050 Baylog Court, Haslett, Michigan, 48840, Ingham County, State of Michigan. The defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Scarby, a police officer of Meridian Township Police Department, that defendant knew or had reason to know was performing his or her duties contrary to statute. This is a felony that is punishable up to a maximum of 2 years and or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D subsection 6 for another violation arising from the same transaction. Or to order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 1, police officer assaulting, resisting, obstructing is a felony punishable by 2 years and or $2,000.
Yes, Your Honor.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, your attorney was able to answer those?
Yes, Your
Do you have any questions about your rights with this court?
No, Your Honor.
All right. And sir, as to police officer assaulting, resisting, obstructing, how do you plead?
No contest.
And you're pleading no contest because of alcohol and civil liability?
Yes, Your Honor.
Yes.
And you had consumed alcohol that day,
Yes, Your Honor.
enough where your memory's fuzzy?
Yes.
All right. And sir, you understand that by pleading, you're giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal, and it becomes the Court of Appeals' choice. If they think your issues are important, they will take up your case, but they don't have to. They would have to take up your case if you had a jury trial and you were unhappy. Do you understand all of that?
Yes, Your Honor.
All right. And you understand you're also giving up certain rights and defenses, such as the presumption of innocence, holding the people to their burden of beyond a reasonable doubt, cross-examining any witnesses and evidence, choosing to provide defense if you wanted, deciding whether or not you wanted to testify, etc. You understand all of that.
Yes, Your Honor.
All right. Has anyone told you what I will do at sentencing?
Ma'am?
Has anyone told you what I will do at sentencing?
No, Your Honor.
And that's because I don't know. I don't know a whole lot about your case, and I'll decide that at the time of sentencing. There's also part of the agreement that says no further upfront jail at sentencing. Do you understand that if I violate that, I would allow you to withdraw the plea, this matter would again go to the pretrial stage. However, if you violate the law or bond conditions between now and sentencing, I don't have to honor that. I could sentence you to jail or prison. And I wouldn't allow you to withdraw your plea because you would have violated the agreement. Do you understand that?
Yes, Your Honor.
All right. Council has provided me a police report by stipulation, and thank you for highlighting it. It is from the Meridian Township Police Department's case report number 2692601450. And it appears this occurred on April 17th, 2026 at approximately 10:58 p.m. at a specific location known as 6050 Baylog, B-A-L-O-G Court in Hazlet, Michigan. And that is Meridian Township, County of Bingham, State of Michigan. Defendant came in contact with law enforcement, and the police note that they were dispatched to that address for a trouble subject complaint, and the mother of the defendant called because he was out of control, screaming, intoxicated, causing issues. When officers arrived, they made contact with defendant who smelled of alcohol, slurred speech, and stumbled as he walked. And while speaking, defendant began to approach the officer multiple times, saying he wanted a hug. He then said, "I'd like to hit you hard." And he kept trying to get closer to officers as Officer Scarby, S-C-A-R-V-E-Y, and Officer Antonio Trevino, Trevino, continued to try and redirect him to go to bed. And he balled up his right fist, pulled, and then put his left hand deep into his left pocket. And officers asked him to take his hands out of his pockets, and he said, "Do you want to fight with me?" and continued to approach the officers. After officers attempted numerous times to create distance between them and defendant and get him to go to bed, he showed signs of active aggression, walked toward officers with a clenched fist, asked if they wanted to fight him, and shoved his right hand into his pocket, refusing to take it out despite verbal commands. At this point, the officer grabbed his left arm, told him to turn around, grabbed both of his hands and placed them behind his back, telling him not to move. He was detained to prevent a potential assault to an officer, and then walked out to a patrol vehicle. While telling him to put down, it was going to pat him down for weapons, he pulled away from officers and ultimately kicked his left leg and knee toward Officer Scarby. The officer was not hit with the knee, however, at this point, defendant was advised that he was now under arrest for resisting. He was given several chances to comply, but continued to approach officers asking to fight, was pulling away and swung his knee. I believe that is sufficient for assault and resisting obstructing. Would you like anything else, Red?
The people are satisfied, Your Honor.
Defense is satisfied, thank you.
You may retrieve the report. Thank you.
Thank you.
Our counsel, where promises, threats, or inducements other than those already placed on the record,
No, Your Honor.
No, Your Honor.
does the court comply with the court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's no contest plea based on civil liability as well as based on intoxication. It seems that he was quite intoxicated, and it's indicated in the police report. Therefore, it's appropriate to have a no contest plea. I also find that based on the police report and stipulation of counsel, count one should enter. The plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, coercion, threats, or promises of leniency. There are sufficient grounds to accept his plea, and therefore count one will enter. Any outstanding warrants, if any, are hereby recalled and dismissed, and the habitual fourth is dismissed in its entirety. We have a sentencing date of August 19th, 2026 at 11 a.m. Serve probation, will come and see you, and we're going to do a they will do a very detailed pre-sentence investigation report, which we'll talk about at sentencing. Is there any bond motion at this time?
If the court would hear one, I would appreciate it.
I'm willing to hear it, but I don't know that I'm going to grant it now. I need to know where he can live. It appears he was living with his mother. I don't know if she wants him back. That would have to be verified, and I would probably only release him on an alcohol tether. So please address all of that.
Thank you, Your Honor. I believe he has been in custody. The bond was he's been in custody since, it looks like April 20th. Does that sound correct, sir?
17th or 18th.
April 18th, pardon me. And he's been sitting on a $25,000 10% cash or 10% bond, pardon me, Your Honor. Obviously, he can't make that. It's a significant amount of money. I do understand the charge that he has now pled to. However, I think at this time, as he has now entered his plea, it's going to result, hopefully, as long as there are no issues between now and sentencing and the granting of a no upfront jail. I would ask court to consider him for reduction of bond or a PR bond. And I think he wanted to say something to me briefly, Your Honor, if I may.
I just thought our agreement was I was getting out of jail today. That
At
was,
the time of sentencing, so that's why I'm entertaining bond, but there has to be certain conditions, okay?
yeah,
So
then I would like to take my plea back. I don't want probation. If I can't get out of jail today,
sir, we're not playing let's make a deal. You just gave a valid plea. I'm not allowing you to withdraw it. The deal was very clear. Let's you and me have a chat, okay? Because I'm trying to be nice. I don't have to let you out. I'm the one that offered that I'm willing to move on for, you talk is 93 days, I'll see you in 93 days. It's your decision, sir. I'm trying to respect your rights and get you out because I think there are better places for you to be and better uses of the bed that you are taking up at county expense. I'm trying to help you out here, sir. But you want to keep doing this, it's 93 days, and that is separate and apart from what we're doing here. That's contempt. You got it? So your deal very clearly, which you signed, which we read on the record, which I asked if you understood, just so we are all clear, it says, sentence agreement of no further upfront jail at the time of sentencing. We are not at sentencing because this is a felony. I have to do sentencing after a pre-sentence investigation report. The legislature wants to waste our time and resources. I don't think we really need one on this. I could certainly go to sentencing right now, but that is not what the law provides. I have to follow the law. I have offered to discuss getting you out now. And if you want to withdraw your plea, I am not allowing it because it's a valid plea. We went over it. You said you understood it. You went over it with your attorney. We made a record of it. I think 3 times the record would reveal we went over that. And so I'm not going to withdraw a valid plea. I am going to consider bond if you behave yourself. Otherwise, I'm going to entertain contempt, which is 93 days and or $7,500. How would you like to proceed, sir? You want to continue this conversation or just go back to jail?
I don't want to be held in contempt, so I really don't want to say anything.
Okay, well, then you respond when I ask you to, and then we'll have an orderly record. The problem, sir, so you understand it is, I have a court reporter here. The record she makes lives on. You can look at the ceiling and ignore me.
I'm not ignoring you, I'm listening.
Okay. The record she makes is for you, because if you want to appeal, that has to be a good record. So we can't interrupt each other and we can't be rude to each other. So behave and all will be good. Otherwise, all right, I think I've been clear. Now, does he have an address that is verifiable that he can go to?
One moment, Your Honor.
You may.
I gotta know where to go. The whole reason I wanted to do the whole 3065 in the first place.
Your Honor, my client has indicated that he is not sure if he could go back to the address in Haslett, which I think was the original plan.
But you have a social worker who can work with him, is that correct?
Yes, Your Honor, and I think we may be able to figure out a plan between that before we get to that August date.
Okay, great. What is the last time you worked, sir?
I can't remember the exact date.
So how do you support yourself?
I was going to school
Where?
at Online Liberty University for ministry when
Okay,
all this crashed.
okay,
I was working before that at Wendy's full time. I couldn't do both of them, so I quit working and I continued my schooling. I ended up in jail.
well, sir, you put yourself there, you drank
Yeah,
alcohol, and you,
I know.
I mean, you wanna go into ministry, but you don't wanna respect law enforcement, I have a problem with that. Maybe you ought to have a conversation with a higher up judge and figure out what direction you wanna go. On behalf of the people, what would you like me to know?
Yes, Your Honor, just to remind the court, Mr. Raymune actually had a previous file, 24-275-FH. that he was on probation for at the time of this incident. He was going to plea at that time, as he wanted his probation revoked so he could serve the remaining time of his sentence in jail as he was homeless. Your Honor ultimately revoked his probation at that time and sentenced him to 365 days with credit for 286 with no earned early release. So
Is he still serving that?
That was on April 21st, so I believe that he would be, Your Honor.
All right,
It was.
Sorry, May 21st
this year?
of this year,
Okay,
correct.
we'll figure that out.
I think that my days was up on the 8th of this month.
That's why we have a sheriff. He's pretty good at math. I'm not. I'll figure it out.
Your Honor, based on our calculations, he has 79 days left.
Okay, we'll figure it
Oh,
out.
he had 79 days on May 21st, so that would at least be another month.
Well, it's jail math, so every week, every 6 days he gets a day, even without the earned early release and all of that, so the jail
That's
math.
also true.
Let's figure that out. He gets a statutory time and their math is very weird and I'm not gonna even presume to start it, but it's for every 6 days, he gets a day, so we'll figure it out.
My time was up on the 8th.
I'm not fighting about it, sir. Don't care. The sheriff's gonna figure it out. It's not what I do. Here's the thing, once I sentence you, you belong to the sheriff. So the sheriff gets to do the math, not me. So I can listen to you all day long, but it means nothing. The sheriff and you can have a conversation. I'm not involved in that. And then we've got this case to worry about. Okay, sir?
Sure, yeah.
Your Honor, if I may?
You may.
Thank you. I've spoken with Mr. Ray, now that I've got that pronunciation in my head, it's stuck. I've spoken with him indicating that especially based on the plea we did here today, that there may be a substance abuse issue here. And I would ask the court, if I had my social worker work on this, if we were able to get him a bed into inpatient treatment prior to sentencing, if the court would allow for a clause or an amendment to his bond to allow for PR for that purpose only from the jail to treatment.
Not till the sentence ends and then we'll figure, I've got some alternates here that we'll figure out, okay?
Yes, Your Honor. I looked up on the jail's website. It does appear that he has no sentencing. He's not under any kind of sentence at this time, according to the jail's website. Take that as you will.
Is that something that you want to do, sir? Go to treatment?
Sure.
All right, sir, I'm gonna give you a $25,000 PR bond. Here's how it's gonna work. You'll report to pretrial services as directed. You will be placed on a scram tether. And there is an indigency grant, which I'm sure you qualify for. You will show all prescriptions to pretrial services from a licensed medical physician within 24 hours, take any psychotropic meds as prescribed, and follow all doctor's recommendations. You will not own, have in your possession, or under your control any weapon, gun, ammunition, imitation of a weapon, or be in the presence of any third party who has any of those items or any contraband whatsoever. If positive, reading on the scram, there will be a secondary test done. So we can figure out if the machine is working or not, if there was obstruction, etc. You will, once you have a residence, maintain that, and any address change shall be reported to pretrial services, the court and counsel within 24 hours. You will appear in court either in person or on Zoom if you are in treatment, August 19th at 11 a.m. You will be released to a verifiable address only after your current jail sentence ends, and it sounds like you do not have an address, so in lieu of that, you'll be released to long-term residential treatment program for alcohol, which also finds housing or sober living afterward. I have a lot of really good programs that will help you in terms of your treatment and then get into sober living. You'll sign all necessary releases and verify, so we can verify that you're doing what you need to do. You will also attend school and be part of a work seek program once you're released. That's probably part of the sober living program, but just to make sure, especially if you cannot reside with your mother, you need to have an income. You need to start adulting, sir, have an income, place to live, follow the law. You understand, sir?
Yeah.
Is there anything I've told you to do you think you cannot do?
Not sure.
I mean, what do you think you can't do?
I'm not sure until I get to doing it, whether it's gonna work or not.
About attitude, sir.
I'm just being honest with you. I'm not sure.
I appreciate that, but I can also just have you sit in the jail. These are not hard things. Follow the law, stay sober, go to treatment. Work with them to find a job, to go to school. That's what you said you were doing.
Yeah, I don't wanna go back to school. I just wanna work,
Well, that's fine. You just gotta figure out what you wanna do, sir. But idle hands get you to putting hands on a bottle and getting intoxicated and assaulting people. So you can attend school and or you may change your mind. Right now you got a bit of an attitude, so after rethinking this, you can go to school and or work. You gotta keep busy, sir. Part of your rehabilitation, especially for men, I have found that when you're not working, you don't feel good about yourself. When you're not productive. And so you find that relief in a bottle. Not a good idea. Is there anything I've said, counsel, that you think is a problem for your client at this point?
I don't think so, Your Honor. I just would like to verify, if he can find if we can obtain from him a verified release address he could go there in lieu of the treatment, or does he have to do the treatment regardless?
We can do it in lieu, but I'm gonna order it anyway as sentencing, so if he wants to get ahead of it, we'll do it.
All right.
I
Thank you.
just, my concern about treatment right now, today, is he's got an attitude, you have to be ready for treatment. So I don't wanna waste a bet on him if he's not ready for treatment. He needs treatment. He needs cognitive behavioral anger management, and a whole lot of other things. I will order that at sentencing. You wanna get ahead of this, go to treatment, get it all handled. Otherwise, you're gonna be on probation a lot longer. I give people this opportunity during this time, so we don't waste these couple of months, so you can get ahead of things. But you use the opportunity how you wish. An address that's verifiable will not be, so we are clear, a homeless shelter.
Understood.
I want a stable, long-term housing situation.
Understood, Your Honor.
So I have clarified that on this. Long-term stable housing, not homeless shelter. Here you go. This is the only option for today, sir. Good luck to you. It's all for the record. Excuse me, Brian.
I was trying to actually. We had miscommunication, but. And told me today I was getting out.
I never said that.
Wishful thinking doesn't count. I said wishful thinking does not count.
Wow, that was weird, huh?
The attorney is now here for the 9:30 suit beyond sentencing, and Mr. Chapman has now arrived for the 11 o'clock sentencing. That's the one you said benchmark for. So I don't know what order you want to handle those in before we start.
Fair.
Oh, thank you.
Oh, gee, he forgot his paper, but I forgot mine.
Let's get as far back to her office. Let's deal with what case she has.
Oh, I just let you go to
I know, I'm not, fat, I don't have a baby. I mean, I still have a baby, it's not in my stomach. How are you? So good to see that you're back.
I am incredible,
I'm
thank you.
so
I've
happy
been
you're
back
back.
since the end of October. Yeah, I'm so happy to be back.
Oh, good, I'm so
Yes.
glad, I'm so glad. Excellent. We're so glad to have you back. We're so
Thank
lucky
you.
to have you back.
So morning, your honor, or afternoon now.
Yes, now, yeah.
President's leave.
Oh my god, it's so hard to cover.
I stopped trying. It's not my case. It's not.
All right, which case are you on?
Sufjan.
Okay, let's do Sufjan.
We got.
There's a
We don't
sentence.
have
We need an
We don't have
answer.
a court reporter.
Wait,
Oh.
well, she'll be back in a
Yeah.
moment. It's been a morning.
I know.
It's
So we have,
sentencing and a probation violation matter. I'm sorry, I'm trying to play prosecutor.
Oh, that is so fun, right? It's a-
I do love it. She
Oh,
had,
well, I don't know why you're not in law school, so.
Judge had to tell me once that I can't play prosecutor.
Right,
I-
Mr. Sarver, you love
I'd like to
that?
tell you something.
He's
Like,
like,
I get y'all are a lot. It's like, I can't believe it now.
No.
I was probation, I love her. I get to, I started sex workers, I think, like, Heather's,
She's
like last thing we did sex ministry, so we were out.
Oh,
until
okay.
later, and then we get to investigate.
All right, where is your plan?
And I get to report it. It's like-
Okay. All right, this is docket 25-2886 FH and 25-2889 FH. People of the state of Michigan versus Ahmed Sufjan. Counsel, your appearance for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Mark Carter appearing on behalf of Mr. Sufjan.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, Your
Are you supposed to be on medication you're not on?
Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you've had enough time to talk with your attorney?
Yes, ma'am.
You pled guilty to domestic violence and or knowingly assaulting a pregnant individual, third offense, punishable by 5 years. Do you recall that?
Yes, ma'am.
All right, thank you. And counsel, are there any corrections, additions, deletions on behalf of the people?
Yes, I'm sorry.
Yes, Your Honor. Specifically in the prior history, offense 404, that is the dismissed case.
Yes.
I don't know why, but for some reason, the home invasion charge is listed as money laundering. It definitely was not money laundering.
Okay, so I'm striking money laundering and putting home invasion. Which version of home invasion?
Neither first, it's been a second degree.
Home invasion second, okay.
Yep. Other than that, people have no corrections.
Okay. And on behalf of your client, any corrections?
Yes, please. With regard to the charge of the plea offense, I'm not sure how it goes into the record, but my understanding was from my notes is he pled guilty to domestic violence third with nothing to do with assaulting.
It's just the name that the legislature did. They amended it a while back. It's silly. Everybody has the same complaint, but whatever. It's just the name of the.
It is what it is.
It's the caption. I mean, they don't ask us these problems. So I get it. We know it's not.
Okay, just making sure. Thank you, Judge. On page 2 of the basic information report.
Yes.
Under my understanding is that the plea was to the DV3. Does your record reflect that the witness intimidation charge was dismissed as part of the, or is going to be dismissed as
It's
part of that plea?
dismissed as, that's on the cover page. It says, count 2, witness bribing, and count 3, child abuse fourth, is to be dismissed, along with docket 252889 FH in its entirety. Now, I don't know if people have the knowledge for me on the new file, but it's, that is, the only thing that's pending and should be reflected, and is reflected, is the domestic violence third.
Very good, thank you.
Any other corrections?
We've already corrected the money laundering issue. My client asked me to inform you that there was some complaint within the body of the PSI that he stole the victim's car. And he just wanted the court to know that the car that was taken was his car. It was titled in his name.
This was his wife, right?
His wife.
So it's an undivided whole, so you can't steal your own car.
I'm with you, Judge.
Okay, so where is that in the report?
It is on PSA, the update, page 3, paragraph 1.
So
There is no claim that a car was stolen.
it's just along, it says the victim stated she observed defendant's brother along with another
Right.
male attempting to take her vehicle from the parking lot. She reported that, I don't know, Belial told her defendant had instructed him to retrieve the vehicle and sell it. I don't know, that's neither here nor there. It can be a marital vehicle if you want, instead of her vehicle.
I'm only pointing that out to the court because my client asked me to point it out to the court.
It's neither here nor there. It's not gonna make, my decision has nothing to do with that.
Thank you, Judge. And my last comment is that I have an objection to the scoring.
Okay,
There's 15 points scored for OB 19, interference with justice. And it suggested he used force or threat of force against another to interfere with the administration of justice. There was testimony taken at the preliminary exam that he asked her not to go to court. However, I don't believe there was any evidence elicited at the exam that he ever threatened force or used force to prevent her from going to court. So if that's accurate, I would submit that that 15 points is inaccurately scored.
I think that's where count 2 came in, the bribing, intimidating, interfering, which is being dismissed, but that's what that's based on, which doesn't have to be a conviction, is my understanding.
I agree with that, Judge, but the information reads through force or threat of force to make out that offense, not just that he asked her not to go.
Well, I guess I don't know the order because I don't get police reports, but it would appear to me, I'll take a stab at this and prosecutors will jump in. We got a domestic violence situation and he's saying, don't do this or whatever. So there's the force right there. So let me see what's going on behalf of the people.
I would know on page 2, the victim said that the defendant was yelling at her, "I can't believe you go to court against me," and then was kicking her while she was holding her infant child, which I believe is force. Now, here's the thing. Even if the court doesn't think that there is evidence of force or agrees with Mr. Hart's argument, we still have 10 points for it, which leaves us in the exact same spot. You'd go down from 45 to 40, you're in the exact same offense variable level. It changes nothing.
I would agree with that.
However, there is evidence in the PSI that force was used.
I would agree with the evidence. I'm leaving it at 15.
Very good.
Anything else? You made your record, Council.
Thanks. I do have to ask you a question.
Yes.
Through fault of me and me alone, I sent you a sentencing, not a memorandum, a submission. I thought I sent it yesterday. I got a call this morning from my assistant saying I'm an idiot, and apparently I put it in the computer but never hit send.
Okay, well, did she send it now?
It's up, yeah. Your office should have it now.
Okay. Let me see if they added it. We're used to getting those things.
It should have been there, Judge. It was.
It wouldn't be in the PSI, it'd be in the file.
It was rubber banded on top of the file.
Oh, yes. No, I don't have anything on top.
I can show you mine.
Is it this, once you get his, make a copy for me.
Okay.
Oh, wait a minute. You know what? It was put in a different file. Let's say that. Okay, I've got it. Okay, rather lengthy. Nice job. Thank you. All right. On behalf of the people, is there a victim here?
I know she was on Zoom earlier, but this is scheduled for 9:30. I don't know if she's still there. She did provide for me
She's still on Zoom.
She provided me a written victim impact statement in addition to what she put in the PSI that I'd like to read to the record.
All right, which,
Judge, can I interrupt for 1 second? Just so the victim can respond to what I'm about to ask. My client's on tether right now. He's on a home arrest tether. For purposes of, he hasn't violated in any way, shape, or form since you placed him on bond. He is asking that, and the recommendations suggest he should remain on tether. I'm asking the court to amend not the tether itself, but to change it from a home arrest tether to just a general GPS tether.
okay, we'll talk about that. And, ma'am, would you like to address the court? You can unmute yourself. Can you allow for that? And you don't have to if you don't wish to. The people can read your letter. Ms. Wahid, did you wish to address the court?
Not at this time, Your Honor.
Okay, thank you. And if you could address to me if you are comfortable with him remaining on tether, but no longer being on house arrest?
I feel like it's better if he stays on house arrest for me and my children.
I'm sorry, could you just say that again? You broke up.
Yeah, I would prefer if he stays on house arrest.
All right, well, he's gotta work and do other things. We'll talk about that, but has he tried to contact you since?
No,
Okay. All right, and are you still married to him?
no, we're divorced.
Okay, and so is there any provision in the divorce judgment for supervised parenting time?
No, I have full custody.
Okay, thank you. Counsel, you may proceed and read the letter.
Thank you. The way Ahmed Sufyan has negatively impacted my life, I will never be able to forget. He destroyed my sense of safety and trust despite being the one I was supposed to.
Hold on, my fingers are frozen, they're not keeping up.
That's okay.
We'll be able to forget.
He destroyed my sense of safety and trust despite being the one I was supposed to feel safe with. He caused me almost 9 years of torment, and I hope he is held accountable for his actions. The way he treated me was inhumane, and the way his family continued to enable him and tell him he had no fault was truly shocking. The problem of abusing women is something that is very common in this family, and I witnessed things I thought I never would. Ahmed isolated me from everyone I cared about, including my own family who lived overseas. For weeks at a time, he would take my phone and completely cut my contact with anyone. Every time he would beat me, leaving multiple bruises across my arms, leg, and back, he would then take my phone and terrorize me so that I would not be able to speak up for myself. He has caused irreversible damage. Emotionally, I will never be able to feel truly safe. Physically, he has ruined my appearance, broken my teeth, and left scars on my body that I cannot get rid of. Living with Ahmed is like living in hell, and he instilled so much fear inside of me and manipulated me so much that it took me almost 9 years for me to finally break free from the cycle of abuse. My reason, my beautiful children who did not deserve to see their mother being beaten and abused. The look of terror on their faces when they would witness what he did haunts me till this day. They gave me the strength to finally say enough was enough, and I needed to stand up for not only myself, but for them. The day I left with nothing, not even our passports, which he had purposefully hidden under the floorboards in the attic, or important documentation. It was the hardest decision of my life, and the days that followed were tough, but not as tough as what I had already been through. I asked the court, if possible, to order this man to never see me or my children again in our lives, so that we are safe from ever being hurt again. He has traumatized me so deeply that I never want to see him again. I also asked the court to give him the maximum possible sentence for his crimes, as although it will not be able to fix what he has done to me, it will provide some peace to know that he was held accountable for his actions and that this is not something that was taken lightly. I also asked the court, if possible, to order him to pay for the damages he has caused to me. When he broke into my apartment, he smashed the TV, ripped up my clothes, and destroyed the place.
Thank you. Is there an amount she's requesting?
I'm checking. I don't believe there's one listed in PSI, so I would ask that restitution simply be left open for, let's say, 3 months for her to gather the materials together. And also to make sure it's for this, because as she made clear, there were incidents, many incidents that happened over these years.
Thank you. May the people, anything else you want me to know?
Yes, Your Honor.
Judge, I'm sorry. I don't believe my client has had a chance to.
He will
Oh,
after,
okay.
he talks after all of you.
Thank you.
Oh, actually, I take that back. It is in the PSI. My apologies. It's on page 5. She estimated damage is around $545.
Okay.
Yeah, my apologies on that, Your Honor.
I'm looking for that in here.
Now, as far as other things to know in this case, I will be upfront. The defendant's guidelines are between 5 to 23. I'm asking that you give him 23, and that's before we then handle the case he was on probation for. The probation that this court granted under HIDA that he violated in under a month by beating her again. Of course, he was actually violating the other court the entire time, because through his own factual statements for the plea hearing, he admitted to the fact that he was living with her in violation of this court's no contact order, which is why, as Amina's already said, she ended up recanting in the first case, leading to that plea, because he was living with her and threatening her. And then after this court granted him that probation, he immediately kept living with her in violation of your orders. And then within, I think it was 28 days, he picked up a new assault and felony case against her, eerily similar to the ones that came before, involving him beating her around the children while she's holding the children and committing witness interference again. Because the first round of this, we dismissed an entirely separate case involving witness interference that he had been committing from the jail. Which, by the way, that's how I know the passport thing is real, because in that first case, before the exam, he was calling his buddies and telling them to go get the passports in the attic. So that way she wouldn't have them. And the defense has provided a lot of supporting letters and letters of support from his coworkers and his family members in their sentencing submission. What's interesting to me is that over and over, family members say he is not a violent person. I've never seen him be violent. I've never known him to be violent. He is a role model. I've never known him to endanger others. He has never exhibited violent or threatening behavior. He's the kind of young man who de-escalates conflict, which tells me they don't know him. Because this is now multiple times in relatively short order, he's been convicted of beating the mother of his children. So I would say take these letters with a very, very large grain of salt, because assuming they're being honest in them, they're talking about Ahmed Sufyan that doesn't exist. That's a facade. The mask that he puts on around other people, so that way they don't know he beats his wife. And at no point in any of these, unless I missed it, in any of these, do any of the family members who are related to these children say they're worried about the children, worried about Amina, hope she's okay, they're sorry for what she went through. None of that. And it really does go to prove what she said in the first paragraph of the statement I read, his family continuing to enable him. Because that's what this is. What was most appalling to me is that they had his 10-year-old brother write you a letter begging for his brother to be let out of jail. They talk about the fact that, well, he's gotten counseling and he's been engaged in classes. They make a very large show of that. What I would direct the court's attention to is the last PSI. The one that we had, what was it, 2024? For the probation case. Page 1 of it. The defendant provided this agent with his high school diploma, associate's degree, and his bachelor's degree. The defendant also has taken it upon himself to attend therapy with a focus on anger management, domestic violence, and cognitive therapy. He was able to show this writer all his completed certificates for
You gotta slow down.
apologies. The defendant has also taken it upon himself to attend therapy with a focus on anger management, domestic violence, and cognitive therapy. He was able to show this writer all his completed certificates for these classes. And he continues to seek therapy and is working on therapy individually for his marriage. He seems to have a lot of supportive family members that he talks to daily. So before he committed these offenses, he had already been doing those classes, already been doing therapy. He used that as argument to this court to be lenient with him at the sentencing for the first case. So the fact that he's now saying, I've done all those again, doesn't mean much to the people, because doing them the first time didn't stop him from immediately violating the orders of this court and beating Amina again. And while he didn't make any statement in the PSI this time, he did last time. I'm going to quote part of it. His description of offense is, my wife and I were arguing as part of an ongoing toxic relationship at the brink of separation. She had threatened to take my kids away, who I love very, very much. And against my better judgment, I let our high emotion get the best of me. And I regrettably put my hands on my wife to
And that high emotion get the best of me.
And I regrettably put my hands on my wife to prevent her from taking my kids. This was a complete lack of judgment on my part, and I am very remorseful and regretful of my actions. In order to prevent this from ever happening again, I voluntarily took up therapy with a focus on anger management, domestic violence, and cognitive therapy. Again, that's from 2024, in order to ever prevent this from happening again. But of course, as we now know, he was actively living with her at the time that he was making these statements in the PSI and making statements to you at the sentencing. He will say whatever he needs to try and avoid trouble. He will do whatever he needs to try and avoid trouble. He will have his family write whatever letters will help him. I don't put any stock into what he has said or the classes he has done, because he did all of this the first time around. He had the support of family members, all of this the first time around, and immediately went and did it again. Top of the guidelines is 23 months. I'm asking you to sentence him to 23 months before we get to the probation case, which is a completely separate sentence that we're going to need to deal with. Thank you.
Judge, if I might, I would ask.
Okay.
I'm sorry, thank you. I'd ask you to look at the first 4 letters that were sent to the court. He's working with a group right now that is a crime prevention reentry program. You've got letters from 2 of the people there. It's called Ripple Effect. I don't know if the court is familiar with that or not. But you've got 2 pretty good letters on his behalf from the people that deal with people that are in my client's situation all the time. And my experience with groups like that, for whatever that's worth, is they don't tolerate a whole lot. They're there to help, but they're not there to necessarily coddle. So I would ask the court to take a look at that. He's been through every course that's available while he spent over a year in jail getting up to this point, which is basically it's well beyond the minimum under the guidelines. It's about halfway up the chain of guidelines. And I would ask the court to obviously listen to what my client has to say.
I've looked at the letters and you have, I don't know, 30 letters here, so about half of them look to be from friends and relatives who respectfully counsel should have intervened long before this. They have an interest in protecting those children, just as the mother does, and they must have known what was going on here. I'm very concerned about that. I do respect that he's finally getting some therapy, but I've had this young man on probation for a while with very little progress. Sir, what would you like me to know?
Is it okay if I read a letter that I wrote?
Certainly.
Your Honor, I stand before this court today with sincere remorse for my actions and conduct. I accept full responsibility for what I've done. There's no excuse for my behavior, and I deeply regret the pain that my actions have caused.
I'm sorry, and there's no excuse for my behavior, and I
deeply regret the pain my actions caused. First and foremost, I want to apologize to Amina. I'm sorry for the hardship that I caused you. You did not deserve to experience what happened. I take full responsibility for my actions. I can't change the past, but I can spend the rest of my life making sure that I never become that person again. I'd like to also apologize to this court, Your Honor, to my family, to my children, and my community. I understand that my actions affected far more people than just myself. I disappointed those who believed in me, and I recognize that trust must be earned through consistent actions, not simply just words. While in jail, I made a decision that I would not waste my time. I knew that one day I would return to society, and I wanted to make sure that I came back a better man than the one I was before. I actively participated in every class that was available to me and completed each and every one. I wanted to learn from my mistakes, understand the thinking and behaviors that led to my incarceration, and prepare myself for a successful return to society. Since my release, I have continued that same commitment to bettering myself. I completed a 12-week anger management course, a dialectic behavioral therapy course. I also completed a coping skills course and several cognitive awareness courses. I also took the initiative to complete several domestic violence courses, and I have participated with Ripple Effect and continued learning and growing through every opportunity available to me. I understand now that a change in my mindset is necessary to correct my conduct and behavior and to learn how to deal with life's everyday stresses and problems. Beyond those courses, I have been committed to counseling. I attend and actively participate in weekly therapy sessions and have met with a psychologist to help me better understand myself, my emotions, and my behaviors. These sessions have challenged me to be honest with myself and to confront the parts of my character that need change. Since my arrest and incarceration, I've realized that changing is not something that just happens overnight. It requires an effort every single day.
I'm sorry, say that last sentence again.
Since my arrest and incarceration, I've realized that changing is not something that happens overnight. It requires effort every single day, accountability, self-discipline, and a willingness to learn. I know that change is not measured by certificates alone, but by living differently every day. And that's the standard I strive to hold myself to. I've also been working with Citizens for Prison Reform and the founder of Ripple Effect, Elias Williams. We've had several insightful conversations about accountability, redemption, and serving others. Mr. Williams has been a huge mentor in my life and is present today in support of me and my rehabilitation. My hope is that one day I can use these experiences to help others avoid making the same mistakes that I made. However, I realize that before I can help anyone else, I must first continue fixing myself, and that's my primary goal. I want to become a man that my children can be proud of, a son my family can respect, and a productive member of society in my community. I realize that I can't erase the past, I can't erase the pain that my actions caused, but I can choose what kind of man I will be moving forward. Every single day, I intend to continue therapy, learning, holding myself accountable, and proving through my conduct and behavior that I've changed for the better. Your Honor, I respectfully ask the court to consider not only the wrong that I've done, but also the work I have done and continue to do to become the best version of myself. I will continue this journey regardless of today's outcome, because becoming a better man is not something I'm doing only for this case. It's something I'm doing for my children, my family, my community, and for myself. Thank you.
Your Honor, if I may, very briefly.
Briefly.
I just need to point out, I'd say 75% of that is what he said in his last sentencing hearing.
I was just looking at that, counsel.
Judge, may we approach?
You may.
And Judge, if I may just add one other thing, the probation department itself does recommend probation in this matter.
Counsel, do you need to talk this?
No, Your Honor.
We have another file. What is your recommendation? I'm gonna work this a little bit backwards. What is your recommendation on that? Revocation or probation?
Thank you, Your Honor. You know, I inherited him while he was in custody, and I obviously completed the updated pre-sentence investigation. I've only supervised him for a short time, which he has been compliant with his tether and with his communication and with reporting, and he obtained gainful employment. However, can only recommend so much because it has to be approved by my supervisor and by our probation violation specialist. It's extremely concerning, his pattern of assault and the dismissal of the high risk or violent related charges that I think is reducing the accountability here. He's been respectful to me, so it has nothing to do with our interaction. Our interactions have been great. Our conversations have been great. I'm trying to instill some things in him and open his eyes up a little bit. But he's just monotone. Like, I'm not feeling remorse from him for any of this. And I have a victim that's gonna live with this for the rest of her life. And so, you know, that the intimidation, the violence, the endangerment, and it wasn't just the wife. His children are now secondary victims of domestic violence, and they're gonna have to deal with this their entire lives. So I will leave it up to the court's discretion. He's 5 to 23 on his new case, 0 to 17. We can throw out the 2 misdemeanors, so we can just get rid of those. Do I think that prison would probably serve him some good for the amount of trauma he has caused his ex-wife and their children? Yes, but you also know that I'm big on getting the treatment and giving them a chance to, like he said, be the best version of themselves. So this is a tough one, Your Honor. I really haven't known him that long, but this stuff that I've put in the investigation, it's extremely concerning. At the very least, I would not take him off tether. And he's maxed out on jail on both dockets. So that's the thing. If he does violate, and I hope he doesn't for the sake of the victim or any future victims for that matter, it's gonna be prison. Thank you, Your Honor.
Judge, if I may.
May.
Thank you. I think one of the things that makes this one a little different than the first case is I don't think he had done any appreciable amount of jail the first time around. He's been sitting in jail for over a year. That in and of itself tends to change many people's minds. Not everybody, I'll be the first to admit that. But for a lot of people, once they feel the sting of the system for over a year, they do change. And he's shown you at least through what he's done since he's been in jail and gotten out of jail, that it appears to me that he's taking this seriously. He knows what it's like to sit in a rat-infested cell with the complete loss of your liberty and living by everybody else's rules with no liberty, no opportunity to make your own decisions for the most part. That's something he never experienced before. So given the fact that he's already done over a year, and given the fact that the probation department is recommending probation, we're not objecting to a continued tether. And we understand that he's got a mountain to climb. However, having done a year already, I would submit to the court that you can, in good conscience, place him on a period of probation with strict requirements. If he messes up in any way, shape, or form, you can throw him in prison for, 4 or 5 years. But I think he's earned the opportunity to show you that he's not the guy that went to jail.
Your Honor, I really didn't want to have to say more things. What the defense just said of, if he screws up, you could send him to prison. That is exactly what you told the defendant you would do the first time around at that first sentencing. If you screw up, I'm sending you to prison. And then he was already violating when you said that. 28 days later, we have new felony files. again, it's a complete repeat of what happened last time around.
Except for the
And
fact that
last
he's
time around-
already spent a year in jail, which tends to change people's outlook on life.
If I could be allowed to finish my sentence. Last time around, the argument from the defense and the defendant was, he spent a month in jail, that's changed him so much, he's been good while he's out.
Not a month, a
The
year.
month last time.
Okay. Okay. Sir, how old are you?
24.
On the file that we have not addressed, were those violations on that file, or were they a result of these new files?
New files.
They were a result of the new files?
They were, except now we know there was more than that, because one of your orders on the old case was, don't have contact with her,
Right.
and he admitted to living with her.
I just want to know, do we need to go through the dog and pony show, or can I
No.
just, do you want to, are you waiving that? Because, I mean, I think I can find him in contempt on that.
Correct, waiving that. We don't
You
need to
wanna go
spend more
through all
time
that?
waiving that.
No.
Great, so on that file, and I'm saying it publicly because I am revoking HIDA. Rarely do that, but I am revoking HIDA. So on 24-6515 FH, this is now public record. HIDA is revoked. He, so that we make a clear record, he, on that file, pled guilty to domestic violence, a 93-day misdemeanor, domestic violence, a 93-day misdemeanor, and then attempted unlawful imprisonment, a 5-year felony. Once I had that file, I ended up with 2 more files. So you got very lucky that as part of this plea agreement, I don't know why they keep giving you chances, but they do. The file that's getting dismissed had allegations of home invasion, second degree, aggravated stalking, malicious destruction of personal property. And all of these are against your wife. Someone you should love, protect, and provide for. Someone who gave you 2 beautiful children you claim to love, and you assaulted her and your children. That is not love, that is control. And while some people like to get high on drugs and alcohol, you get high on controlling people weaker than you. That is a problem for this court. So yes, I said I'd send you away. We did do a year, and I am really on the fence between prison, going over guidelines. Let me just say 23 months doesn't sit well with me. And what I can do, so that we're on the same page, is I can give a 5-year felony, so I can, based on this escalation, 1 file turning into 3 files. 5 years is 60 months. I could do 40 months to 60 months. So that's about 3.5 years to 5 years. How does that sound to you, sir?
Doesn't sound good at all. I am remorseful. I think I'm just nervous, and that's why I'm coming off with this monotone. But I understand the severity of my actions, understand the consequences. Doesn't sound good at all.
I'm not worried about you being monotone. What I'm worried about is you escalating your anger against women and children who you allegedly love. That is not love, sir. That is abuse. And you have traumatized your children and your ex-wife. Thankfully, she finally saw the light, and she is your ex. You need to stay away from her for the rest of your life. Are you paying child support?
Yes, ma'am.
Is that through the friend of the court or the family court division?
Yes, ma'am.
All right. Sir. I probably shouldn't do this. But I'm gonna put you on 36 months probation where you cannot get off early. Normally, you can do half of it and get off early. You're gonna be on the full 36 months. If you so much as blink wrong, you're gonna be in prison. And I will make good on my promise that you have a prosecutor and a probation agent who will remind me of my promise. Not only that, I'm gonna write it on the top of my file and highlight it, that you will go to prison over guidelines. There are no, you're out of chances. You're out of fast talking. You're out of excuses. You have a lot of hard work to do. You don't do the hard work, prison awaits. You are out of jail time. And you've accumulated and amassed a record that if you commit any offenses against the community, any other women, children, whatever, your guidelines are gonna go up, up, up. And at some point, you're gonna go to prison on those. It doesn't get better here. It gets much, much worse. Now, you're only 24. Your brain doesn't stop developing until you're 25 or 26. Hopefully, you're getting a clue. And let me tell you about probation. You have an exceptional probation agent who has my personal cell phone number, as they all do. If there's new charges, counsel, there will be an immediate bench warrant revocation and an emergency hearing. I'm not waiting for their so-called 3 violations. He's had them. It'll just be prison. There's nothing else to do here.
Understood.
All of these wonderful letters that you amassed, where were they in terms of helping him during all of this? They have a responsibility to protect those children as much as he does. Well, he has more of a father. The father actually has the role in that, but his family members, very smart people, educated people, medical field, they have an oath to protect, to report. CPS should have been involved a long, long, long time ago. Don't know why that didn't happen, except this is a family secret. There are no more secrets. Sir, you're out of secret time. You're out of jail time. It will be prison. And you'll be in a jumpsuit quicker than you can take that tie off. Do you understand?
Yes, ma'am.
So this is 36 months, no early release. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, drug paraphernalia. You will be within 1,000 feet where you will remain away from your children and your ex-wife. You will not be in their presence, school, work, residence, social events, school events, nothing. You will not have any communication. Your ex-wife was given sole physical, sole legal, and that's where it's going to remain. If at some point there is a feeling that you are rehabilitated where you can have parenting time, it would be supervised. And then we'll go from there, but it has to be by the authority of the family court judge, this court, and a trained trauma therapist. In addition, with the comfort level of the mother and an agreed to person who gets along with both parties to exchange the children. I do not know what trauma has been inflicted on these children, and they may have to go to a lot of therapy before they even want to see you. I suspect they're probably afraid of you, and at this point, you haven't seen them for a long time, so you're a stranger to them. You bought that, they didn't. You will remain on the GPS tether for now. There'll be no longer the house arrest. You will, however, be monitored. You'll not obstruct that tether. If you do, you'll be back in jail, possibly prison. You will continue to be in treatment for the long-term domestic violence treatment. anger management, and possibly trauma treatment. I don't know where you get off thinking you can beat women and children, except that there's gotta be something in your background that happened to you where you didn't have power and now you're taking power over other people. Maybe you were beaten, I really don't know. But you need to talk to a trained trauma therapist to figure out where your trauma is, where you are now causing trauma on others. It is not lost on me that hurt people hurt people. And somewhere in your background, you think that you have a free license to hurt others, which tells me something happened to you. So we're gonna figure it out with a trained trauma therapist. You will not use any object as a weapon. You will not own, use, have under your control or area of control a weapon or imitation of a weapon. You'll not be in the presence of anyone who has those items or any ammunition. You'll not use any object as a weapon. That includes your fists, your hands, and your mouth. You'll comply with all written and verbal orders of probation and all treatment providers. You'll allow probation to residents at any time for probation supervision and submit to a search of your vehicle, residence, cell phone, and computer without the need of a warrant if there's reason to believe you have items that might violate the conditions of your probation. You must report any arrest, police contact, personal protection, order placed on you, loss of employment, change of residence within 24 hours. Weekends and holidays are accepted. Something happens on a Friday, tell us on Monday. Monday's a holiday, you tell us on Tuesday. You will maintain your employment. Are you able to support yourself and pay child support being an Uber driver?
I'm not doing,
What
Uber
are you doing
anymore.
now?
I'm doing sales,
Sales where?
at Best Furniture Outlet.
Okay, and how's that going? You able to support yourself on that?
Yeah, it's commission based, so it's up and down, but
All right, if you're not able to do that, you will get a second job or a different job. You will work no less than 30 hours per week, and you will not give your employer any cause to terminate you. You'll serve 365 days jail. How much credit does he have? I'm looking at
379.
379. So you're out of jail time. Credit for 379. Any violation that results in further jail will result in prison. So you are on notice, sir. Short leash, a short leash, short leash, short leash.
understand. Yes, ma'am.
You will pay crime victims assessment in the amount of $130 and $68 state cost. You'll pay $30 per month probation oversight. You will not engage in recreational use of marijuana or alcohol. If you need any of those things, you'll present a prescription, only use it as prescribed. Half the people,
The only, for this file, did you want him being on curfew for that time? I know no house arrest. I know, I just wanted to clarify.
I don't know that he needs to have that.
Understood. Then the
But
other,
if it is needed, we'll deal with it at that time. I think that we need, he's been on it long enough where he hasn't violated, so if he does, we'll just go backward. And technically, we'll just restrain him in prison. I'm not interested in adding more requirements. The more freedom we give him, the more he will be allowed to violate if he has that proclivity to decide to violate instead of be healed. And then we have the warden to take care of him. You need the warden to babysit you, you got it, sir.
then the last thing in this file is the restitution request of the
And then the
$545.
restitution will be, how much is it?
545 is what was listed.
545, however, will be open for as long as, I'm gonna open it, keep it open for a year. And that would be to pay for any co-pays for medical or other treatment. It's hard for me to believe that with the teeth and everything else she's got going on and all of the things he did to her, that's all the restitution. So I'm leaving it open so she can figure out what medical and emotional needs she and the children need, and he will solely be responsible for that, irrespective of the co-pays that the family court may have divided during this time as it relates to this case. he will pay 100% of those co-pays.
Understood. And then for the other file, 24615 FH, I know the court's already said it's a vote HIDA, and I believe the intent is to close the file out.
Nope, I'm leaving it open because I'll tell you why, that was my original intent. But on this file, I'm increasing it to the 36 months probation. These will run together. But on this file, he has got, charges that I think if things get really bad, if things stay well, he will be successfully discharged from probation. If they get really bad, I don't have to do concurrent sentencing. I can do consecutive. And so that's why I'm leaving it open. I think he needs some motivation. The one who has power and control here, sir, is me.
I think we are at least required to close out regards to the 2 misdemeanors, because I believe we're past it.
Yes, the 2 misdemeanors can go away. He's already served on that, but
Absolutely.
the felonies, we're done.
On that file, he technically has 410 days credit because it's 31 in addition to what he's got.
Okay. So that's fine.
Understood.
I'll order that jail and so he's on the misdemeanors, though, he's got,
So his probation on that file would be.
so on the domestic violence, the 2 counts is 93 days with credit for how much?
410.
And 10, and then we will increase that up to the 3 years probation. I think we still have some time on that. And these will run together and we'll figure out what's happening. And then is it the people's intent to still dismiss this file and you're going to give me a nollie?
Absolutely, Your Honor. It's part of the agreement.
So you have a lot to lose. You have everything to gain. 42 days to appeal and to request appellate counsel on both files, please, sir. Please, appellate rights.
Oh.
They're right there in front of you. He needs 2, 1 for each file. If you don't like this, sir, you certainly can appeal me.
I appreciate your time today, Your Honor, and hopefully one day I can be successful in this probation and we'll have a different, more positive conversation.
I deal in evidence, sir. I look forward to that. Words are cheap. I deal in evidence. You have a probation agent who is extraordinary. If there's an issue, talk about it with her. She will be contacting me immediately. So you can do a song and dance of excuses, but she's not going to tolerate that either. Evidence is what she deals in and I deal in.
Yes, ma'am.
Anything I need to amend?
No, Your Honor, thank you.
Thank you.
When's the next time you're seeing him?
His next report date will be June 2nd, Thursday.
July 2nd?
Yep, sure, July 2nd.
On all files, July 2nd. Understood?
Yes, ma'am.
Thank you. That's all for this record.
Thank you, Your Honor.
Yeah, we don't need it unless it's planning to appeal. We don't.
Thank you, Judge.
Your Honor,
Yes.
being very cognizant of you and your staff and need for food. Mr. Chapman is now here. That was the 11 o'clock sentencing that you reached the benchmark for. We want to handle that quickly.
11.
It was scheduled for 11, Deonta Chapman.
No. What are we doing on this?
You had ordered a benchmark. We need to address bond violations, other warrants, and his failure to appear at the PSI.
Okay,
But the result is we're not going to be able to do a sentencing today because we never did the PSI.
all right. So, just a minute. No? I don't have any files. What's his name?
Chapman?
Oh, Deontay?
Yes.
Okay, got it. All right, we are back. I'm sorry, Nancy, do you have it? Okay, I'm ready. We are back on the record on docket 24693 FC, People State of Michigan versus Deontay Antoine Chapman. Counsel, your appearance for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Jacob Sarnes IV, Assistant Public Defender here on behalf of Mr. Chapman. Mr. Chapman's president of the podium. He's standing to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury? Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
You're supposed to have medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No, ma'am.
And have you had an opportunity to speak with your attorney?
Briefly, yeah.
Well, you were supposed to be here, I think, at 9 o'clock or maybe 9:30.
No,
it was 11.
11.
I got here 11.
Last one was 9 o'clock.
Oh, last one was 9, okay, 11, it is now 1:05, so you are a couple of hours late. I think there was a bench warrant, so now I am recalling the bench warrant. However, sir, I had instructed you after you pled to report to probation for a pre-sentence investigation report. That did not happen. So, and you pledged, let's see, no contest to home invasion, first degree assault with intent to do great bodily harm less than murder, interfering with a crime report, committing crime, threatening to kill or injure, and then domestic violence. We have very crimes here. Do you care whether you go to jail or prison?
Yes, ma'am.
Well, what
It
happened?
was just a miscommunication.
Who is miscommunication?
Between me and I thought I can do it on Zoom. So when they send me the thing, I'll be waiting on Zoom and it never pop up. And then they emailed me, told me to call. I called, I got in touch with them and they said it was too late.
The email, you got an email?
Yeah,
You'll start from there.
I got an email and she told me to text her number. Call her number. I called her. When I finally got in touch with her, she said, well, it's too late to do it. I was trying to get in touch with her. I told her I was trying to get in touch with them too. So it was just a miscommunication. I thought I could do it on
Okay,
Zoom.
no.
Slow down, sir.
Okay, you're trying to get in touch with them too?
Yes, I was trying to contact them too.
And you've lost access to your phone.
Yeah, I don't have a cell phone.
I'm sorry, we're in America. You can walk into any store and say, can I use your phone? You can walk to your neighbors. You got family members, they got phones?
Yes, ma'am.
Is there some reason you can't say, can I borrow your phone?
No, ma'am.
Well, then get a clue, sir. That is not an excuse in America today. Now, when we only had, a few telephones in the 18 or 1900s or whatever it was, or you had to walk to a phone booth or telephone lines were down and we had these problems, that's an issue. It's not an issue today. Everyone's got a cell phone. Everyone. Don't give me that excuse ever.
Yes, ma'am.
Your Honor, I'm going to ask he be remanded today for a couple of reasons. First, I need to address what he just said, because the pre-sentence report that was attempted by the agent, as of June 12th is when she wrote it, she said that she had called him on multiple numbers, messaged him, emailed him, and as of June 12th had gotten zero response from him. There is no evidence other than him saying right now that he talked to someone, that he actually talked to someone. Then they also note in there that he has 3 active warrants for failing to appear for 3 different court cases. On top of that, a request for a bench warrant was sent to this court at the end of May of last year because the defendant was found from JSG to have been shielding his tether to block the location going out. And then when the shielding failed, he was at the victim's house. So a bench warrant request was sent to this court May 26th of 2026. I don't know if a bench warrant was issued for that, but I'd ask that he be remanded because when he did finally talk to pretrial services on the 29th, he not only denied all this, he said that at no point was he in Lansing. And what the tether mapping shows of the data is when the shielding failed, he was at the victim's house. He was then in Lansing and then drove back from Lansing to his house in, I forget what city it is, but not
Okay.
Lansing.
Well, that's gonna take a hearing, but let me tell you what's interesting to me. AM County front of the court, that's this building. There's a 100-mile pickup, but you're right in this building. And it's docket 22343 DP, so there's paternity, there's child support case. And it's a violation of a court order. And that was entered August 25th, 2025, 100-mile pickup. Then we have 54A District Court, failure to appear for arraignment on an alleged larceny. That was issued April 1st, 2026, 25-mile pickup. You're within 25 miles of that court. And then 66 District Court, docket 21, ST 0374B, failure to appear for a show cause hearing on a careless driving. There's 100-mile pickup, and that was issued on June 3rd, 2026. Council, have any of these been cleared up, or are they still outstanding?
Your Honor, if I could have a moment with my client.
You may.
Thank you. Your Honor, to the best of Mr. Chapman's knowledge, he did try to get those cleared up. He's been to Shiawassee several times. He thought that was taken care of.
I went to court, I done paid money, I don't know why that keep popping up.
And then you also, to the best of your knowledge, to the case out of 54A, you thought that was resolved as
I
well.
thought that the larceny was dismissed, I don't know how another larceny or something like that.
Then what?
I don't know the other case.
All right, Ms. Easter, here's the thing, one person talking at a time. And I was issued this robe and this gavel, not a crystal ball. So if you don't know, I don't know. But the prosecutors indicated to me they've checked the lien and none of these were cleared up. So you are remanded to jail and your attorney can discuss with me bond and all of that. We figure all this out. I have no choice but to remand this to jail and there's 3 warrants. You gotta go, figure it out. You've got an attorney, say anything at 63 days, 93 days contempt and or $7,500. Sir, don't talk over me. If you need to say something, I will address you again, but there is no choice here. Counsel, you know how to find me and we will address bond if and when, and maybe you can help him untangle the spider web of crimes that are alleged.
Understood, Your Honor. Thank you.
Thank you. Anything else, sir? How'd you get here today?
Car.
Okay, you have somebody who can drive the car so you don't get some kind of tickets on that?
Yeah, I'm good, thank you, have a good day.
Hold on, we need a new sentencing date.
Your sentencing date is gonna be, September 16th at 11:30.
Understood, Your Honor. Thank you.
Thank you.
And then you'll cooperate with probation for that PSIR. Thank you. All right, we need to take a brief break.
I appreciate you handling that before the break, Your Honor.
Well,
The only one, yeah.
Yeah, I could use that.
we'll return shortly.
Good to go.
This is docket 26169NI, Anthony Edward Marino versus Gabrielle Gretchen Hackett and Dennis Lewis Hackett Jr. Counsel, your appearances for the record.
Good afternoon, Your Honor. Benjamin Muth here on behalf of the plaintiff, Anthony Edward Marino.
Good afternoon, Your Honor. Megan Sloan for the defendant. Hackett.
All right, and this is plaintiff's motion for entry of default judgment. Counsel?
That's correct, Your Honor. So at the outset, I would object to the defendant participating in this motion on any substantive way because the default was entered against the defendant, and as of today's date, that default has not been set aside. So pursuant to 2.603A, the defendant cannot participate in today's hearing unless that default has been set aside. Now, Your Honor, as a factual background, we are here today as a result of a motor vehicle crash that occurred in Ingham County on September 13th of 2024. The victim of that motor vehicle crash is the young man sitting to my right, Anthony Edward Marino. Mr. Marino was on a scooter in the crosswalk on the campus of Michigan State University when he was struck by defendant Gabrielle Hackett in her automobile. That automobile was owned by defendant Dennis Lewis Hackett Jr. Our claim is against both of those defendants. Firstly, against Gabrielle Hackett for her negligence. Secondly, against Dennis Lewis Hackett for his ownership of the vehicle and his vicarious liability under the Owner's Liability Act of Michigan. Now, as a preliminary matter, the plaintiff filed this lawsuit in January of 2026. The answer was served. After the answer was served, plaintiff attempted to communicate with defense counsel on numerous occasions. We sent a proposed scheduling order to them. No response was given. We appeared for the scheduling hearing. Nobody was here, so the court entered a default at that time. The plaintiff served that default on defendant the same day, May 12th, 2026. We received no response from the defendant. We then waited the 7 days. We filed this motion for entry of a judgment on the default because there's no sum certain in plaintiff's complaint.
There's no what, please?
Sum certain. Because there was no sum certain in plaintiff's complaint, the court has to hold a hearing to enter the amount of monetary judgment. That motion was filed on June 12th of 2026 and was served upon defendants. And so we are here today for that motion. Now, I would just point out that we did hear from defense counsel last week. However, that was only until this motion was filed. We had had no communication after the default was entered, no communication in sequence scheduling order dates. So at this point, the default was entered against defendants under 2.603A, and pursuant to the court rules, defendant cannot participate. So I would like to withhold any arguments or discussion about the underlying default itself to the July 14th hearing date, which is when defendant's motion to set aside default is scheduled for.
Okay. Ma'am, there was no response. I have a default that I signed on May 12th, 2026.
Yes, Your Honor. I first would just like to apologize for the issues that we've had with our system and calendaring and all of these things as far as the default. I don't think my office, unfortunately, got the paper notice until pretty late in May, and obviously that's not okay. And I've done everything I can to make sure that these things are taken care of and that it's noted that this is a paper court and that we need to be more, on the lookout for these things. We just didn't receive it right away, Your Honor. And as far as I'm trying to be respectful of counsel's arguments of, my participation today, Your Honor, but I just would like to state that I did not inadvertently miss the scheduling. It wasn't on purpose. It was not willful. I didn't have it on my calendar. I don't know why it wasn't noted in my file. I apologize to counsel, and that's why I contacted him last week to try to come to an agreement. We've given all of the outstanding things that they had requested. Again, I apologize that I was under the impression certain things had been filed and they had not. But, Your Honor, we did.
Have you remained the attorney of record? You are Megan Sloan?
Yes.
And are you licensed in Illinois and Michigan?
No, just Michigan, Your Honor.
Okay, so, but you're working out of Chicago?
No, Your Honor, we don't have a physical office in the state of Michigan, so for some reason they send all of our mail to Chicago. Somebody goes to the office once a week to sort it and.
Let me understand this. You're an attorney, your firm is practicing in Michigan, but you have a address that you go to once a week in Chicago?
No, I'm sorry, Your Honor, I don't ever go there. We don't have a physical office in Michigan, so all of our mail goes to Chicago.
Why?
I don't know, Your Honor, we told them that this is not the best.
Who's
way to-
them?
Allstate, I mean, that's who I work for, is Allstate.
All right, well, Allstate's gonna have a lesson because I'm not removing the default. They've not, this is not your fault, this is their fault. How do you have something in Michigan, or you practice in Michigan, but they go once a week in, wherever in Chicago? So if there's an emergency motion orders by the court, you're delayed, that's on them. That's not on these people. So I'm very confused how Allstate, they fight every single claim. And how they think that this is an appropriate way to represent their clients or the people who are affected by this is not a good excuse. So you can do your research, we can have our other hearing, we can do whatever, but send a message to them, not happy, not appropriate. I can't imagine my brother and sister judges feel any differently. If you want to work for a company that is divided like this, I'd worry if I were you.
I understand, Your Honor.
Whoever their director is or whatever, maybe they should read the rules that we all operate under as judges and attorneys, but this is certainly inappropriate and actually gave me the impression, I started looking to see if we had, if you were licensed in Chicago and you had permission to practice here and yet you're licensed here, but your home office is in Chicago and the right and the left hand don't know what they're doing, that affects plaintiff, delays my docket, my case, and we have, look at this, 4 or 5 inches of papers, and your client hasn't been there. Not your fault, their fault. They want to operate business like this, it's sloppy, I don't do that. Have a seat. Sir, are you prepared to have the hearing in regard to the damages?
Yes, Your Honor.
Let's proceed.
Okay, as an outset, Your Honor, I would just like to make a record as to the medical history of Anthony Reno. I know the court has the 4 or 5 inches of papers there that we submitted, but just for the record. Following this crash, Mr. Reno was taken to the emergency room where x-rays of his right wrist were done. That diagnosed an acute common unit scaphoid wrist fracture with slight fracture diastasis. In layman's words, he had a broken wrist. The treatment for that broken wrist was what we call an open reduction internal fixation, which means Mr. Reno's hand was cut open and a screw was placed into his wrist, specifically his scaphoid bone, which on page 6 of plaintiff's motion, there's a computer generated diagram of where that screw went. And the purpose of that screw, Your Honor, is to try to put the bone back together because it was essentially broken and it did not go back together. So the goal of the hardware is to manually force that bone back together so that it can heal. That doesn't always work, unfortunately, but that is the purpose of hardware. In Mr. Reno's case, he underwent that surgery on September 30th of 2024. He's never hurt his wrist before. He's never had surgery before. He's never been in any sort of workplace accident or other motor vehicle. He's a young, healthy engineering student at Michigan State University, and he has to undergo this surgery with Dr. Katranji on September 30th of 2024. Following that, about 2 or 3 days later, Anthony goes immediately to the emergency room because he's having a fever because there's an infection in his wrist, which is a common complication when there's any sort of surgery in an individual. So he has to go back to the ER. He's complaining of 10 out of 10 pain. He has a 103.8 degree fever. And so they have to take care of him there and give him antibiotics. Following that, after a period of healing and not having any mobility, he starts occupational therapy at athletico-physical occupational therapy so that he can try and regain some range of motion in his wrist. Unfortunately, that occupational therapy didn't work and he had delayed healing, and eventually that led to what we call non-union, which essentially means that the hardware didn't work. So the hardware's goal is to hold that scaphoid bone together, and unfortunately for Anthony, it didn't work. And so following more imaging studies, the reason it didn't work is because Anthony was suffering from what we call avascular necrosis, which means that the bone was not getting blood, which means that the bone itself was dying. And because the bone itself was dying, it was never going to heal. And so Anthony had to undergo a second surgery to attempt to cure the avascular necrosis and now the dead scaphoid bone in his wrist. So that surgery means that Dr. Catrangi went in again and took that screw out because the screw wasn't working anymore. And what he did is he attempted to pack the area around the broken scaphoid bone with what physicians call osseous material, which is packed bone. And so the goal is essentially to cement the joint with bone and blood in the hopes that that packed bone and blood material will cause the scaphoid bone to regrow in a way that it wasn't doing on its own. So that was the second surgery that Mr. Marino underwent, and that was on March 10th of 2025. Now, since then, Mr. Marino had continued to go through occupational therapy at Athletico, and the records that we supplied to the court, voluminous records through Athletico, show that even though Mr. Marino has done 2 surgeries and all of his OT appointments, he still has extremely limited range of motion in his right wrist, and he still has extremely limited physical activity and strength in his right wrist that he's going to demonstrate for the court today. And most importantly, what Anthony has been told by his surgeon, Dr. Catrangi, is that today is probably the best condition that Anthony's wrist is going to be in for the rest of his life. Meaning it's going to get progressively worse with age because Anthony is going to develop early onset of arthritis in that joint because that joint still is not fully healed. And so because there are multiple fracture sites, there's scar tissue now, there's cartilage, there was a cyst that formed. All of these things are going to lead to advanced onset of arthritis. And Dr. Catrangi says that there might be a third surgery on the horizon for Mr. Marino. And that third surgery is what Dr. Catrangi has described as a scaphoid fusion. So essentially what that means is that he would take out that scaphoid bone and put in basically hardware that would act as a fake scaphoid bone. So while it might prevent future arthritis, it will be a permanent impairment on Mr. Marino's both range of motion, his strength, his physical abilities, his ADLs, his work life for the rest of his life.
Does he have any atrophy as a result of not being able to fully use it? Is that also affecting or not?
That is affecting it, and that is reflected in the Athletico records because Mr. Marino has lost the ability to lift heavy objects with his right hand. That subsequently weakens the muscles in the forearm and to a lesser extent the bicep as well. So that is present. So with all that being said, I would like to swear in Mr. Marino and allow him to provide some live testimony about how these impairments have affected his life. And could he do so from council table, Your Honor?
How about from here?
Okay, that sounds good.
Have a seat here, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. You have a seat. Please state and spell your name when you are comfortable, and the microphone is adjustable. Feel free to adjust it.
Anthony Edward Marino. He said to spell it as well.
Yes, sir.
ANTHONYEDWARD MERINO.
All right. You have some papers there with you. What are those?
So these are testimony notes that I wrote down to basically.
Okay, you can use those to refresh your memory when needed. So flip that over and let us know when you need it. In accordance with the rules, sir.
Yes,
You'll
sir.
advise him. Thank you. You may proceed.
Okay, Mr. Marino, are you here? Well, why are you here today?
I'm here to give a testimony about basically why this, what this accident has affected for the rest of my life.
What part of your body was injured as a result of this accident?
There were three main target areas. It was my right wrist, right knee, and my left shoulder.
What area of those injuries has been the most significant for you?
My right wrist.
What was your first indication to yourself that your right wrist was injured as a result of this?
When I got hit and I was in the ambulance on the way to Sparrow Hospital, the medical worker said that he noticed that my wrist was, there's like a lot of inflammation building up already. And when I went to the hospital, they already diagnosed it and said that, your wrist has a very serious fracture and you have to already have a surgery.
What did it feel like?
It was really painful. It was honestly very scary because I've never broken any bones prior to this. And it was honestly a very traumatic experience for me.
What did your wrist feel like in between getting hit by the defendant and your first surgery?
It felt very puffy, like I could see a lot of inflammation building up. It almost looked like it didn't look normal at all. It was very painful. They put this wrap around my wrist, and I was literally resting every day just with my wrist on the pillow, and it was pulsing. It was almost like a heartbeat, and I was counting the days till my first surgery because I really wanted my wrist to feel better.
What sort of physical activities were you able to do with your wrist prior to your first surgery?
I'm a very active kid. I was in the gym every day. I was actually coming from the gym, like going home the day I got hit. And I'm into sports a lot. I'm playing football a lot, basketball, as well as I always go down to Florida to race go-karts and fish with my dad, and golf as well in Michigan is also a big thing for me. With my stepdad, that's a big way we bond as well.
Are you able to golf now post-crash?
With severe limitations, it is very difficult to golf because, as I make contact with the ball, all that force, every time it hurts my wrist, and it's honestly no longer enjoyable to play golf.
Is your range of motion in your right wrist the same today as it was prior to this incident?
No.
Can you demonstrate for us in the court right now your range of motion?
So this is my left. Obviously got the normal range of motion. Then my right, that's all I can move it back and then forward. So
Are you right-handed?
yeah.
Are you able to write with it?
If same with typing, like if I do it for a long period of time, it starts to ache.
How long does it take before you're typing and writing for your right wrist to start to ache?
Give or take half an hour.
What was your field of study at MSU when the crash happened?
Mechanical engineering.
Is it the same now?
Yeah.
Did this crash and your injury delay your studies at all?
Yes, it delayed it over a year.
When were you supposed to graduate from Michigan State?
26th of May.
You mean May of 2026?
Yeah.
So like last month?
Yeah, last month.
When are you scheduled to graduate now?
I projected 2027 in the fall semester, which would be December.
And what about this crash delayed your graduation?
This crash, the recovery as well as the surgeries that delayed my schooling and my inability, to do my homework on the computer, or whether it's writing formulas on the sheets, I was not able to do that. So I had to do what's called a medical drop for 2 semesters, and again, that did delay my schooling.
medical drop meaning that the MSU allowed you to basically defer?
Yes,
Did you have to pay for those classes, or did MSU refund you for that?
I still had to pay for the classes.
Now, are there any, well, let me ask you this. What is your understanding of your future medical potential based on your conversations with your practicing physicians?
What I understand from my doctor is that, like you said earlier, you're gonna develop that serious arthritis, and honestly, it's just downhill as I get older. There's no really looking forward to anything. You know, I'm gonna experience more pain, more mobility limitations, more function limitations. So that's what my understanding is.
Has the possibility of future surgery been brought up too?
Yes.
And what has been, what is your understanding of that?
So there are the four corner fusion, which is basically they're going to fuse the four main bones that are in my wrist together. And my doctor told me once we go through with that, there's definitely no saving any mobility at that point.
So the fusion would basically mean a straight wrist forever?
Yeah.
That's your understanding?
Yeah.
Okay. You mentioned golf. You also mentioned go-karting. Can you tell us a little bit about go-karting and how this crash affected it?
Yeah, I mean, ever since I was 6 years old, go-karting's been my number one passion, like motorsports in general. And when I turned 14, I had a really good opportunity to compete in South Florida. And I've been practicing for years. And when I got hit, that completely crashed that dream of mine. And now I'm not able to withstand the forces as well as the constant intense vibration of the go-kart while it's on the track, especially since I'm racing anywhere from 60 to 75 miles an hour. So to really turn 90 degrees into, implement that turning force, it's too much on my wrist now.
Can you do it all?
If it's like these franchise places where it's like 20, 30 miles an hour, it's a lot more bearable, but it still has that aching pain.
But at the high speed, 60 miles an hour, are you able to do that?
No, I can't anymore.
You also mentioned fishing. Can you tell us a little bit about your fishing pre and post crash?
Yeah, so my parents are split. My mom's in Michigan, my dad's in Florida, and I always try to visit my dad, twice a year. And a big way we bond is fishing in the Bahamas or off the coast of Key Largo. And I was always known to be like the kid who would bring in the big fish with my little cousin or whoever needed help. And now it seems the tables have turned, there's a big fish, my wrist can't handle it anymore, so I gotta hand it to my dad. And every time I do that, we just look at each other with that very upset look because we knew how I was beforehand.
And forgive my ignorance, but as a right-handed fisherman, your right hand would be at the top of the pole?
Yeah, and I would be reeling with my left on a traditional spinner rod.
And is there a pain when you would attempt that?
Yeah.
Did you ever have that pain before this crash?
No.
You also mentioned that you were very active in the gym. Tell us a little bit about your gym routine pre and post crash.
Yeah, I would work out 6 days a week. I had a 3-day split that I was doing push-pull legs.
You was doing what?
Push-pull legs. And I would repeat that twice a week to attain that 6-day week. And a big thing that I noticed, like for the difference with my wrist, is you need a lot of strength to grab, dumbbells as well as support the barbell. And I noticed it, like my left hand can easily grab like a 30-pounder, and when I grab with my right wrist, I notice that it will always flare down because it doesn't have the structural, integrity to really bring the dumbbell up. or even pushing against the barbell, I can feel the pain in my wrist because all of that tension is focusing on it. So my confidence in the gym hasn't been as high as it would be before the crash.
Do you have scars on your wrist?
Yes, I do.
Can you show us those scars?
So this one here was from my first surgery where they put the first screw in. And then this one was when they took the screw out and inserted the bone graft.
Are there any areas of your life when you're just doing your normal living that you find that your wrist impacts it?
Yeah, I mean, simple things like scrubbing in the shower, putting clothes on, or even trying to cut a steak. I'm always feeling, that aching pain in my wrist. And funny enough, now I'm used to drinking, any liquid with my left hand because I could never bend my wrist or support the glass enough with my right. So that's something that's, really changed in my life.
Is there anything else you want the court to know?
So a big thing for me during this accident was, like you said, it was super scary, having to go under for surgery because I've never done that before and feeling that pain that I've never felt in my life. So I had to get prescribed narcotics for the first time just so I can sleep a few hours, that was a very big experience.
Are you still using medication to sleep?
Thankfully, no, but now it's very hard to sleep without any lingering pain.
So you were on the campus of Michigan State.
Yes.
You were a student there?
Yeah.
What year were you in?
I was third year.
Did you graduate?
No.
Are you still attending?
Yeah.
And so what's your major?
Mechanical engineer.
So mechanical engineering, is this going to affect your ability to work in that field, or will you be limited to jobs in that field?
Yes, I will be limited. I'm actually experiencing that now with my internship because, I do a lot of computer work as well as writing notes. And like I said before, I have to take that break because of the aching pain. And I'm even trying to help out, the machine operators as much as I can, moving components around. And if that component is too heavy for me, I just can't do it. Whereas a normal person would be able to carry it.
So mechanical engineering is a pretty big field. What was the reason that you entered, or as you exit, what was your goal in terms of your ultimate job?
Yeah, so my goal was to work in aviation and automotive because
what?
I'd like to work in calibration. That was always my dream. I actually wanted to be a pilot too, but I wanted to start out as an engineer.
Okay.
And
So how does this affect calibration or the jobs that are in it?
yeah, so whenever the hiring manager asks me, do you have any limitations? And I always have to tell them, I might have to have breaks here and there when I'm doing, my 3D modeling on the computer because that takes a long time, as well as writing down notes and having to move anything in any manufacturing plant.
So will it prevent you from attaining your goal, or will you be able to get your goal, but it will be with some limitations that you'll have to have an employer who agrees with those?
You would have to have what?
An employer who agrees with those. I mean, there's certain ADA accommodations and things that are required, but is that what you're gonna need or not?
I will need some, grace with my limitations, but I still will be able to achieve my goal. God willing.
And is there, with your career, and I don't know how, I know if you were an attorney, I can tell you many ways your career could blossom, okay? And as we get in our careers, there's different choices we make as we learn what we like and what we don't. Is there anything aside from maybe flying a plane that you have had as your goal where now it's questionable that you'll be able to attain it? Does that make sense to you? So you're talking about going into calibration, what's next for you, or is that where you remain for the next 40 years or what?
Yeah, so, I mean, it definitely did change because, for example, in automotive, a lot of the calibration comes down to like driving vehicles and, while on the spot, you're looking at the data and seeing like how, you can change it for the better. But now it's more looking like maybe I'm at a computer more often, because it's a lot more serviceable because all I have to do is take a little break to allow my wrist to, rest. But in terms of more hands-on work, it's definitely less likely.
Well, what about day-to-day things like laundry, doing dishes, I don't know, washing your car, things like that?
So for that, in terms of dishes, my roommate does it for me.
So you're having difficulty?
Yeah.
What about laundry baskets, things like that?
Laundry it's a little difficult, but that's a lot more serviceable just because I just have to carry it and then just like throw it in the washer. But thankfully for my upcoming lease, I'm gonna have a dishwasher, so that'll make it a lot easier. Because before we had to, grab the sponge and like scrub it, and that used a lot of pain when I had to carry like a plate and like really scrub it.
Are you in a dating relationship?
No.
Have you been since the accident?
No.
Is there anything about how your hand maneuvers that you think in social settings or in a dating relationship, once you have some free time? I know it's tough in college to pursue that kind of thing, but that you have experienced might limit your ability to engage with another person?
100%.
Like what?
Yeah, I mean, when I have feelings for a girl and and I think, well, if I don't have good function in my hands, I'm my own worst enemy. I always talk down myself. I'm like, okay, I can't really provide her that physical, I guess.
Well, you can, but it'll be
ability,
different.
but it's just very limited, and I feel like I get judged for it.
Okay. So you're carrying around some stress and embarrassment and apprehension.
Yeah.
Is that fair? I don't want to put words in your mouth.
No, yeah, that's fair. It's been a very mental roller coaster.
And you don't have any children, right?
No.
Is that something you want in the future?
Yeah.
The way you manipulate your hands, would you be comfortable changing diapers or holding a child, or don't you know yet?
I do not know.
Are there other activities day to day, like doing dishes, laundry, that you find yourself limited or uncertain of because of your injuries and the prognosis in the future?
Besides the sports and
Can you button your shirts?
yes, I can.
How about cleaning your house, vacuuming, things like that?
I can use like a microfiber to kind of wipe the table, but we try to utilize the automated cleaning like a robot vacuum, just so I don't have to like push around a manual one throughout the whole house.
So a manual, when you've tried it and it's difficult, is that fair or not?
Yeah, because we have this.
When you say we, it's you and your roommate.
This is for me and my mom.
Oh, you and your mom,
Yeah.
okay.
We have this like old school like vacuum, and it's like super heavy. It's like stainless steel, and I'd have to use my left to vacuum with that one because it's
Okay.
hard to drag around, but
Okay, thank you. Anything else you want me to know? Do you want to look at your notes before you, okay,
Yeah.
go ahead.
that should cover everything.
Anything further?
Nothing further, Your Honor, from Mr. Marino.
Ma'am, technically you haven't responded. Is there anything we missed that you'd be concerned about? Thank you, sir. You may step down. Thank you. Counsel?
Yes, Your Honor. Thank you to the court for hearing the testimony of Mr. Marino and for reviewing the medical records and the other exhibits that plaintiff has provided to the court in support of this motion. I have prepared here a draft default judgment motion. I know that the plaintiff did seek an amount on the face of the motion itself, but after hearing Mr. Marino's testimony, Your Honor, we would respectfully ask for the following. For past pain and suffering, we'd ask the court for $1 million. For future pain and suffering, for all the things that Mr. Marino detailed regarding his potential dating life, having kids, his career, his loss of his passion, of being physical with mechanical engineering as opposed to being behind a desk, which is the loss of a passion. We would ask the court for $5 million for future pain and suffering.
Sir, how old are you now?
Your Honor, Mr. Marino is about to turn 24. I have a copy of the US life tables with, if I may approach, Your Honor.
You may. I mean, technically, I think those have gone out the window, but you can still do some work with them, but.
So according to the latest US life table, which was published in 2025, Mr. Marino is about to turn 24 years old in a couple days. And according to the table, he has 53.9 years of expected life.
So technically, counsel, that's $92,765 a year that you're asking for.
I don't have the math in front of me, but I trust you, Your Honor.
Well, you ought to not trust me in math. I have to trust my computer, my phone. You can check yours. I just would like you to address that amount. We're not disputing it, but it seems like a lot of money. I don't know what his earning potential is and how much he'll lose. I don't know that he's gonna lose some, but he will lose some, I think eventually, because he seems like a highly motivated young man who has a career that will not be able to exceed what his ultimate dreams were, in addition to his hobbies, one of which could render him potential awards, ribbons, money, etc. So
So yes, that is the amount that we're asking for. And again, this really is about the loss of passion for Mr. Marino. This is about the pain and suffering of losing the ability to be hands-on with the career that he wanted to. It would be like if an attorney could not be a trial attorney and was stuck doing contract review. What he sought in his career was to be hands-on with motor vehicles or airplanes, collaborating those things in the field with other engineers. And his testimony today is that because of his physical limitations, he'll still have a career in his opinion, but it might not be the hands-on career that he really wanted. And that's the pain and suffering that we're asking the court to compensate today.
The court is persuaded by not just the youth of the plaintiff, but also the fact that it's his dominant hand. He has limited motion, there's atrophy, he may need another surgery, and ultimately, by the time he gets, and I'm not a doctor, but as he gets older, 30, 40, 50, and so forth, with the limited range and atrophy, in fact, it may result in a hand that is not usable, which is the loss of a limb. So that is not lost on me, so I want it to be very clear as to what I'm doing and why. I am looking at this long-term, not just as past pain and suffering, medical costs and all of that, but also future, and the future as outlined in his voluminous medical, the history he's testified to. It is apparent that this young man really has a future where he will no longer be right-handed, but rather one-handed. For that reason, and for everything he's gone through and what he has lost, which is significant when you do the multiplying factors in his future, I am going to grant $5 million.
Thank you, Your Honor. I have a proposed order to present to the court.
You may. Counsel, you have past pain and suffering. Did the insurance cover all the medical, or?
Yes, Your Honor. Mr. Marino's medical has been covered by his own no-fault insurance. And so this claim is about past pain and suffering and future pain and suffering.
And is it likely that insurance will cover the future medical? They don't always cover pre-existing.
Under the Michigan No Fault Act, Mr. Marino would be entitled to lifetime medical for any complications arising out of the motor vehicle crash or his risk.
Do you understand that, sir? And that would be up for you to pursue, and then if you had issues with it, consult with your attorney?
Yes.
Okay. Court has signed this. I just want to make a further record that I had signed the, let me see if I can find it. I've just gone through papers here, but the I just want to address the default. So I did sign the default. Counsel, maybe you have it. I mixed up, I think, as I was going through, looking through some of the papers, the medicals that I I signed the default. I think it was May, the middle of May, right? May 12th, something like that.
May I approach, Your Honor?
Yeah. Oh, I have it right here. Yeah, there was a request for default. There was a request for default that the court entered May 12th, 2026, and I did indicate a hearing on damages shall be scheduled by plaintiff by order of this honorable court. And today is June 24th. So I don't know when defendant filed anything. I don't have that in the file at this moment. I understand there is a hearing that's been set, and we'll see. It looks like I have a huge file where defense has failed to plead or otherwise defend. So I have signed this. I think it's appropriate given the situation, and I do understand Ms. Sloan. I do understand your predicament, but it's one caused by your employer. And I don't want you to be held accountable for that. I just want to say that on the record, because our licenses are important and we are sometimes at the mercy of the employer. And your employer did not act responsibly or timely in this matter, and it should not reflect on you. I know that I want to say to you that you are good enough to take the fall. Good attorneys do that. But the way I review this file, this is solely on the laziness of your client, who, if they want to ensure people in Michigan should have an office here or a daily runner to Chicago who can fax, send by train, we'll get it the same day from Chicago. There's lots of ways to get information here to Michigan. They have not availed themselves of the technology, the court rules, or to otherwise defend or plead appropriately here. I will not waste my time or the plaintiff's time, or for that matter, your time, ma'am. I do appreciate what you said. I'm willing to hear the other motion, but I want to make it clear that I think this is the appropriate thing to do, given the lackadaisical nature of the defendant, and the court will not wait for someone who sits on their rights. And clearly the defendant has sat on their rights. The plaintiff has been here every step of the way, has provided voluminous information, documentation, and complied with the scheduling orders and all orders of the court. So therefore, this judgment will stand, and we'll make sure that you all get copies. Is there anything else for the record?
Well, thank you, Your Honor.
You'd like to?
Thank you.
If you guys just hang tight, I'll get you copies.
This is docket 254419NO, Tabitha Williams versus Carolina Apartments LLC. Counsel, your appearances for the record.
Carol Lancer, Your Honor, on behalf of Carolina Apartments, the defendant in this action, and the cross plaintiff.
Stephen Fugre, Your Honor, on behalf of defendant 42 North, as well as cross defendant with respect to their cross claim. And to my left is Suki Baines, who's actually a newer associate at our firm. She's just kind of shy.
Oh, well, you've got a good person to shadow. Welcome. Thank you. All right, counsel, this is defendant cross plaintiff's Carolina Apartments response. I have the response to defendant 42 North Outdoor Services LLC motion for summary disposition and cross motion for summary disposition. And so I think you're up, sir.
All right, may I approach? So good afternoon, Your Honor. Hope you're doing well. In this particular case, we represent 42 North, and they are the landscaper and snowplow company for Carolina Apartments that were hired by the owner of them, which was Simtob Management Services Company LLC. So essentially, just kind of for context, Your Honor, my client, 42 North, comes in as a cross defendant because Carolina Apartments is seeking indemnification in the event they are held liable for Ms. Williams' claim for a slip and fall that occurred on December 21st of 2024.
So in this particular case, Your Honor, the claim against my client, my plaintiff has been dismissed. And it really
Against my client,
has been dismissed, sorry about that.
no.
And really what we're addressing right now is the remaining claim against my client, would be the cross claim as to indemnification. So really, Your Honor, our argument can be broken down into three main segments. One, the indemnification language that's under subsection 9 of the contract, the landscaping contract, is very, very narrow. And that what that means is it's not an indemnification of omission. It's an indemnification of services that were done improperly. And what I mean by that is it's based upon performance, not nonfeasance, or what is also known as an omission. And I would like to direct Your Honor, before I go into subsection B, exhibit B to our motion, specifically number 9. So when Your Honor is able to look at that, we also cited to it, Your Honor, in our motion itself on page, 9 out of 17. All right, so specifically, it states, if the landscaper, which would be my client, 42 North, or any of its employees are injured while performing the services, the customer is not held liable for the injuries. Period. Indemnity. And a subsection of that main pair provision says customer seeks protection against any personal liability, claim, action, suit, loss, or damage that may result from the landscaper's participation in their services performed. Specifically, I would add the last sentence, which says, landscaper agrees to indemnify and hold harmless customer and assigns against any and all claims of any kind arising from or related or services provided by the landscaper. In my experience when in defending against these kind of claims, generally an indemnification clause is broad. Instead of saying arising from, it would say arising out of. Instead of just saying from services performed, it would talk about acts and omissions. It would include an omission. And why is that important? Well, it's important, Your Honor, because this slip and fall occurred on December 21st of 2024. My client didn't perform any services that day. The fall occurred at 1 p.m. during the day. And according to the contract, they were to come out only upon approval by the owner or the maintenance individual to come out and snow plow the parking lot once snow stops falling within 24 hours.
No approval and no request.
No request, no approval that day.
So was it contingent upon come out when snow stops falling, or come out if and when we call you?
It's a mixture of two. One, it has to be approved.
Okay,
And two, it has to be within 24 hours of the snow falling.
and those did not happen.
No. Plaintiff testified that it was snowing for 3 days leading up to the fall. So snowfall never stopped. So at the same time, cross plaintiff, Carolina Apartments has not provided any evidence to suggest the contrary. If you look at their motion talks about a third-party beneficiary theory that we never even argued. There's no proofs against actually an argument that this particular provision is very narrow. But in addition to that, Your Honor, the contract speaks as to the snow plowing the parking lot and salting the parking lot, as I indicated previously, when upon approval of the owner or the maintenance person, but also when the snow stops. But what's important here is that plaintiff fell on a sidewalk. Well, the sidewalk condition is that they will provide snow plowing as well as salting on the perimeter of the property when there's at least 2 inches of snow, but there also has to be pre-approval. Again, there is no dispute, or at least material fact, that they have provided that suggests that they requested it the day of the fall. Now, they did request it the day before, and my client did come out the day before, but they're not claiming that my client anywhere in their complaint or in their answer response that my client performed negligently. They're saying that we didn't perform at all, and therefore there's an omission. So in respect to that, Your Honor, we have provided a few cases because case law in this particular avenue speaks as to mostly when the provisions are very broad, when they say stuff like arising out of, or they incorporate language like omissions. Here, this is a very, very narrow
indemnification provision, which quite frankly, in my career, I have not really seen as narrow as this. We have cited the Green v. Sterling Woods. We have cited to Green v. Sterling Woods Condo Association. It's an unpublished per curiam opinion of the Michigan Court of Appeals. It was issued on April 7th, 2011, where similar to here, the court felt that the indemnification clause in that particular case was very narrow and didn't apply because the services, it was basically an issue of omission, and the indemnification clause like here didn't speak as to omissions. So the other cases speak as to omissions and has a broad scope, and therefore they found that there's an indemnification clause that was enforceable, unlike here where you don't have those facts. Now, in addition to that, Your Honor, on page, and I actually printed out a page, one of the pages for you just in case the picture itself wasn't clear, and I can show counsel as well. But on page 6, this is the second issue. The second issue being that the plaintiff didn't fall where we were supposed to provide the services. In other words, we never contracted to provide the services where plaintiff fell. According to their own maintenance individual, and we also cited to the owner itself, if you look at the transcript testimony, which again would be Exhibit E, actually, I don't think I said it before, but Exhibit E, and the question was, is page 14, specifically lines 10. It talks about all sidewalks, right, for clearing all the sidewalks. And in response, Tim LaPlante, who is the maintenance individual, the head of maintenance for the company, says all the sidewalks, there is no set person for all the sidewalks. No set person, I mean, you asked one question,
Okay.
you know, speak slower.
Yeah, it's been a long day. There is no set person for all the sidewalks, no set.
Person, or I mean, you asked one question of Light, who is in charge of all of them. Well, yeah, because I guess I can jump forward a little bit and say 42 North was required. There were maps that were drawn up. They were required to do, and I stress, the sidewalk around that butted up next to the parking lot, like we had talked about. Essentially saying that we're responsible for the perimeter of the sidewalk abutting the parking lot. And Your Honor, may I approach?
Yeah.
This was the exhibit that was provided during the deposition testimony that was highlighted and confirmed by them as to our responsibility. As you can see, the drawing, at least the highlighted portion, is in the entire section of the outside perimeter of the property, not the inside. According to plaintiff, as we pointed out in our motion, she indicated, and also we attach as Exhibit B, I believe, a photograph of, at least Exhibit B to her transcript. We showed you the photograph of where she fell. It wasn't abutting the parking lot. It was on the internal side of the premises. Therefore, how can we be held liable for something that we weren't responsible to do? So that's issue number 2. Issue number 3, and I think it's probably the most damning argument as to them, is when you're drafting a contract, and in this case, we provided proof under Exhibit B as to who created it. In this particular case, 42 Carolina and Sitma, I apologize if I mispronounced his name, created the agreement, the landscaper agreement. And in that particular case, they are, if it's ambiguous or in any way not can be read by in plain and ordinary language, it's going to go against the drafter, not the draftee. So in other words, because they are the drafter, they're going to be held to an interpretation that's not favorable to them. So when you look at subsection 9 of the contract, the subtitle, or at least the main provision, speaks as to the landscaper and his employees. Okay, you have to read a contract in its whole, its entirety. So when you read the contract in its whole, in its entirety, you'll see that the first provision only speaks as the landscaper and his employees. And then the subsection to it, which is under it and indented, it speaks nothing as to the third party. So in other words, as the agreement is written, as the indemnification clause is provided, we are only liable in the event the landscaper or his employees are injured, not as to any third party. There is no clarification in the contract. This is very, very clear that the intent was the landscaper's employees, not any other third party or tenant. Does it say tenant in there? Does it say third party? No, it only speaks as a landscaper or his employees. So under those three reasons, Your Honor, we believe that summary disposition is appropriate. I would like to add, Your Honor, as you're well aware, under MCR 2.116 G4, that when a party comes in and provides support for their position, the other side is supposed to rebut it with affidavits or evidence to support their position to rebut our arguments. If you look at their response, 80% of their response deals with a third-party beneficiary argument that we never argued. For the purposes of this motion, we're not arguing that because the contract was between the owner and the landscaper, that it doesn't apply to the apartment complex. If you look at our motion, there's nothing in there. We mentioned that it was with a different party, but we never say that we should get summary disposition on that basis. But here they go for about, I don't know, 5-6 pages out of 9, talking about third-party beneficiary. They don't even address the argument as the narrow scope of it. So, as Your Honor is aware, the Michigan Court of Appeals has held that when a party does not provide case law or facts to support their position, the court, as in the trial court, is not tasked to have to find a reason or basis to support their position. So, and that's essentially what they're asking this court to do. And as Your Honor is well aware, as with the Court of Appeals, if you don't respond to a particular argument or motion, to the motion, then it's going to constitute as being waived. In other words, be constituted as waived. In other words, they are agreeing to our relief. So at the same time, they said there's a question of fact as to whether plaintiff felt was in the area of the contract. Well, their own individual in terms of the service manager openly testified that it's the outer perimeter. And that's an admission, Your Honor. As you know, MRE, the Michigan Rules of Evidence, those are admissions and they can be used against them. And unfortunately, that's sworn testimony. So those basis.
So in this document that you gave me, and counsel, I presume you've seen this.
Yes, Your Honor, I have, and I might be able to address that.
So these orange lines here
Yeah, correct.
is where the plowing or whatever took, salting, whatever they did, but not inside where she fell.
That's correct.
And there's nothing in the contract or the request that said you'll do this inside.
Correct. The language, according to the owner, the language, basically he felt that it did cover the inside, but he openly admitted that it was very vague and it wasn't clear. But then the maintenance individual came in who actually deals with this property, says, no, it's only the premises. But even then, Your Honor, I mean, even it's the outside perimeter, I mean, but even then, Your Honor, I think the biggest hump that they have to get over is the fact of the written language applying to only landscaper and its employees, but also the fact that it's very narrow and only speaks as the performance of services, which they never called out to do.
So ultimately, you're saying that the landowner had the responsibility, didn't request the service, and your client should not be held responsible for services that were not rendered nor required.
Yes, particularly under the indemnification clause, that specifies the terms of indemnification. And as Your Honor is aware, in Michigan, we're free to contract, and we have to follow the terms. And if they're the drafter and if they're the ones that deal with it, I'm sorry, but you can't hold us liable for something that you drafted and you're trying to hold us liable for.
Thank you.
Thank you, Your Honor.
Response, please.
Thank you, Judge.
I could not disagree more vehemently with counsel.
That's why we're here.
And that's why we're here. And I don't know if he is aware, because someone else was taking depositions, that the plaintiff was actually deposed twice. And there was testimony specifically about where she fell. And she testified that she fell. And if I could approach with the floor here.
You can show it. Yeah, sure.
So this is a photograph where the plaintiff marked where she fell. And if you look at that aerial photograph, which my client disputes, by the way, but the testimony is that
this circle?
Yes.
Where is
is
it
in that, pardon me?
Oh, so it's on
It's
the
on-
orange line at the bottom of the.
Yes, it's on a perimeter sidewalk,
Okay,
not on the interior sidewalks. And they, by their own admission, were responsible for the perimeter sidewalks. council says that the language is not broad, and I don't understand how he reaches that conclusion. The contract reads that the 42 North must indemnify and hold harmless customer and the signs against any and all claims arising out of or related to the provision of the services by the landscaper. Landscaper that was there the day before, when the landscaper left the premises, it was still icy and a mess. That's the plaintiff's testimony. Icy and a mess after the visit by these contractors. So that language is clearly triggered. And that's clearly triggered. And that's why we ask for summary disposition in our favor, Your Honor. Council wants to read into the language that's in the contract some temporal limitation that says, well, if they come out and they do a bad job on the first day, so there's still ice and there's a trip and fall, it's not their fault because the fall happened the next day. There's no such limitation in the language at all. It says any and all claims arising out of or related to. You can't be more broad than that, Your Honor.
Or was the weather continuing where the client should have said, and we want you back out to clean this, or no? The weather the next day was.
No, it was not snowing the next day. It was not snowing on the day of the call. So the premises were in the same condition as they were when 42 North left the property the day before. And that is, there were patches of ice on there and there was snow in the area where she fell.
So this is Michigan. We have ice. Was there salt put down or not? Should it have been put down? Should she have taken more care?
Well, we paid for salt. You know, on the day of the accident, the representatives from 42 North testified that they were out that day. And that, as it turns out, they're not a very sophisticated company. They have 2 trucks and 2 guys, each had 1 truck. They actually shovel the sidewalks with shovels by hand. And then they take 5-gallon buckets of rock salt and they walk around and sprinkle them on the ground. He couldn't speak specifically to having applied it in the area where the plaintiff claimed she fell, but he acknowledged that there was photographic evidence that there was ice and snow on the perimeter sidewalk where she claimed she fell.
Well, and I don't know the science of it, but I do know, only because we live in Michigan, and I've had this problem myself in my own home, is that certain salt does not melt ice when it's a certain degree outside. So was that also playing in here or not, or don't we know?
There's no record evidence that was or was not, Your Honor.
Thank you.
So I say all that to say, council wants you to construe the language very narrowly. At a minimum, that's a question of fact for the jury to decide. But I think the language is broad enough on its own, and the location of the fall is obvious enough on its own that the language is triggered, and we ought to have summary disposition in our favor, Your Honor.
Yes, thank you. Point 1, we did not go out that day. Council did not rebut the fact that they never called us to go out.
But he's saying this stems from the day before when you were out.
That's what he's trying to argue now. But he said this is all about omission. And when you look at the contract, and Your Honor, you are supposed to interpret the contract based upon the plain and ordinary language. That's exactly what you're supposed to do. You're supposed to look at it and say, okay, what do these words mean? And he read to you, customer seeks protection against any personal liability, claim, action, suit, loss, or damage that may result from the landscaper's participation in their services performed. They're alleging that my client failed to perform the services. So when it's participation in the services
I
performed.
think he's just admitted they did perform the services in the area that you identified on that orange line.
Their allegations are that we omitted and failed to provide services on the date of the loss. We never provided services on the date of loss because they never asked us to do it.
Yes, but I agree with that. I think he agrees with that, but that was on the day she fell. But the argument, as I understand it, and I can be wrong, it's late in the day, is that the services were provided the day before, and those were not sufficient to protect people who could have slipped um, despite the weather having been the same that second day.
So let's talk about that. Plaintiff has not provided any proof to show that it was stopped snowing that day. Plaintiff was there. She testified that it kept snowing. Under the contract, we didn't have to provide the services. They never asked us to come out. We don't have to provide services unless within 24 hours of the time it stopped. Plaintiff is saying, oh, it stopped snowing. Where's the proof? Your Honor, he's telling you this, but as you're well aware at trial, attorney statements are not evidence. What's evidence is the documentation. Did plaintiff attach that to his motion? No. Did he show that it stopped snowing? No. So right now we have 1-0. We have a statement saying, because from personal experience, she can testify that it continued to snow. No one's saying that it wasn't snowing. So that's unfortunate for them because they didn't rebut that under G4. So in addition to that, Your Honor, as he came up here, he never even addressed the argument as to the fact that the landscaper employees are the only ones that are considered under the indemnification clause. It's very, very specific as to these individuals. Doesn't say anything as to a third party. So we have a situation here, Your Honor. Let's say, for example, there's a question of fact as to where she fell. Okay, let's just say that there is. I disagree with her testimony as we provided in our brief, but even then, one, as to the narrow language, we provide a case law, which he has not even rebutted, showing that our cases are very akin in terms of the language of the provision, as well as
Cases are very akin, showing what?
the language of the provision, as well as the facts of our case. We provided that support for it. Also, we provided the provision itself, and we're supposed to read it if it's unambiguous. This is unambiguous. This tells you what the services are and what our liability is. So unfortunately, it's just poorly drafted. He didn't come up here and tell you that his client didn't draft this. He's coming up in here and saying, well, this person was injured. I disagree with this is broad, and therefore it's a question of fact and jury. No, Your Honor, it's a question of law. This is a question of law because it's an interpretation of a contract that is unambiguous. So it's a question of law that you can decide upon. So with that, Your Honor, unless you have any other questions, please, I'm happy to respond.
No, I don't have any questions.
Thank you, Your Honor.
Any further?
I'm just taking a little back here, Judge. He wants to know that his client was out on the day before the incident. That his client was paid for snow removal. His client was paid for ice abatement. The photograph testified to by the plaintiff, and the picture that I showed you where she fell, it's right in the area that his client's supposed to take care of. And there was ice there and no fresh snow. We didn't need to call them again. The problem was the problem that they left and created from the day before.
All right. I'm denying both motions for summary disposition based on material facts at issue, and this may very well be a question of law, but I would like to have some kind of offer proof or testimony as to what's happened here. We have two very, very, very different scenarios. So at this point, I'm denying without prejudice. We can have an evidentiary hearing if you would like in lieu of trial. Otherwise, where do you have case eval and
yeah, if I may on that point,
yeah.
Your Honor, plaintiff counsel for the plaintiff isn't present today. He couldn't be because he had a conflict, but he did speak with me, and I communicated this to brother counsel prior to our hearing. We are currently scheduled for trial on August 28th. We are scheduled for return facilitation on August 27th.
Move the trial.
Thank you very much.
Move the trial, go and do that. If I need to have an evidentiary hearing, I think there are issues of material fact. Mr. Forcre, I could very well rule on the law as you suggest, but I think there is a question of fact that I'm concerned about. I don't want to send this to the Court of Appeals only for it to land back on my bench. So I think we need to make a larger record. I haven't seen all of what you have. And so if you all want me to have an evidentiary hearing so I can look as to whether it's fact or law, I'm happy to do that. Meanwhile, go to mediation, case eval, continue your work, and let me know how I can help resolve this.
Sure, just a quick question. At least as the third argument regarding the landscaper as well as the employee, because there's no other language, what are you looking for, at least in terms of an evidentiary hearing as to those specific issues? Because there's no facts, at least that could be elicited to address that.
I think there's some in the record of his employees and of the.
No, it
Mr.
applies
Stenthat.
to third parties, because there's no language in there that says it applies to third parties, so I guess, how can we look at facts there?
It says any and all, any and all.
Claims,
Any
it
and
doesn't
all
say any and all
claims.
persons. It
And
says
he
any and all
wants you to
claims.
read that as being limited to claims by employees, but that is not what the contract says.
But it's
He
clear,
makes this paragraph.
We'll have a hearing, just vote, just solely on that language if you want. You can both bring me case law, sir. The council's right in terms of, you need to bring me some affidavits, case law, whatever, otherwise he may very well win on not having the proper information in accordance with the case law and court rules. So I
I'll
think
have to do
there's
that.
some more hearing. Primarily, if I thought the court of appeals wouldn't give it back to me, but I'm certain they will based on this. So let's make a larger record or get to trial. Thank you. You may
Your Honor,
rescind this.
may we just submit a post stipulation that says that trial is adjourned with a blank date for your court to fill in, or how do we?
Trial is adjourned until, go back and get a date. We'll have you as a backup to another civil because civil hardly goes, so I'm sure we can get you another date pretty quickly. If you just go back and get another date, we can do it in December or January, whatever you like. I don't know how long case eval will take, and you may want that other evidentiary hearing in front of me so I can limit the issues at best. All right?
Thank you, Your Honor.
we'll cut that, Brian, yeah.
Yeah.
Thank
you.
Your Honor, I just wanted to say that.
Hello.
Have you
All right.